exempts exchange offerings with existing security holders. Under Section 18, B, 4, C, transactions subject to Section 3, A, 9, are federal covered securities. See Section 102, 7. Notice requirements in the earlier 1956 Act and RUSA accordingly would be preempted by the Securities Act of 1933. See Section 18, A, of the Securities Act of 1933. Otherwise this exemption is substantively identical to the 1956 Act and RUSA. 17 Section 202, 16 offerings registered under this Act and the Securities Act of 1933, prior provisions, 1956 Act Section 402, B, 12, RUSA Section 402, 15. This exemption generally follows the 1956 Act and RUSA. Rule 165 of the Securities Act of 1933, which was adopted in 1999, allows the offerer of securities in a business combination to make written communications that offer securities for sale before a registration statement is filed as long as specified conditions are satisfied. RUSA Section 402, 15, 2, also required that a registration statement be filed under this Act, but not yet be effective. By eliminating the filing requirement, this exemption will reach the offer, but not the sale, of a security that is anticipated to be a federal covered security by applying for listing on the New York Stock Exchange or other exchange specified in Section 18, B, 1, of the Securities Act of 1933, but the listing and federal covered security status has not yet become effective. 18 Section 202, 17 offerings when registration has been filed, but is not effective under this Act and exempt from the Securities Act of 1933, prior provisions, RUSA Section 402, 16. If a rule is adopted by the administrator, a solicitation of interest document must accompany a registration by qualification as specified in Section 304, B, 13. 58 oral offers may be made after a registration statement has been filed, both before and after a registration statement is effective. This exemption does not operate unless the administrator adopts a rule under 202, 17, B. 19 Section 202, 18 Control transactions, prior provision, RUSA Section 402, 17. Until 1972, mergers and similar transactions were not considered to involve sales and did not have to register under the Securities Act of 1933. In 1972, the Securities and Exchange Commission adopted Rule 145 defining many mergers and similar transactions to be sales and abandoned its earlier no-sale doctrine. C3 Lewis Loss and Joel Seligman, Securities Regulation 1262-1280, 3D ed. Reb. 1999. Because most merger and similar transactions require shareholder approval and shareholders often have appraisal rights if they choose to dissent, the potential for abuse is less than in an offering of securities for cash. When appropriate, the administrator can deny, condition, limit or revoke this exemption under Section 204. Section 202, 18, does not follow the requirement in RUSA Section 402, 17, that written notice of the transactions and a copy of the solicitation materials be given to the administrator 10 days before the consummation of the transaction and, that the administrator is empowered to disallow the exemption within the next 10 days. 20 Section 202, 19 Rescission offers, no prior provision. See Section 510 for discussion of rescission offers. 21 Section 202, 20 Out-of-state offers or sales, source of law, Colorado Section 11-51-102, 7. Compare A.S. Goldman & Co., Inc. v. New Jersey BUR of Seconds, 163 F.3d 780, 3d Sir 1999, which held that under the United States Constitution's Commerce Clause a state could authorize a securities administrator to prevent a broker-dealer from selling securities from a state to purchasers in other states where purchase of the securities was authorized. The concluding phrase "and is not part of an unlawful plan or scheme to evade this act" is intended to preclude reliance on this exemption by boiler rooms and others engaged in illegal activities. Section 202(20) provides an exemption from securities registration and does not address an administrator's power to investigate and bring enforcement actions under Articles 5 and 6. 22 Section 202(21) Employee Benefit Plans, Prior Provision, RUSA Section 401, b. 12. The 1956 Act Section 402, a. 11, was limited to investment contracts issued in connection with specified employee benefit plans if the administrator was given 30 days written notice. In 1979, the United States Supreme Court in International BHD of Teamsters v. Daniel, 439 U.S. 551, 1979, held that a non-contributory, mandatory pension plan subject to the Employee Retirement Income Security Act of 1974, ERISA, was not a security within the meaning of the Securities Act of 1933 or the Securities Exchange Act of 1934. The Securities and Exchange Commission staff subsequently took the position that the interests of employees in involuntary, 59 contributory plans are not securities. Secretary Act Rel 6188, 19 SEC Doc. 465, 473, 1980. Both contributory and non-contributory pension or welfare plans subject to ERISA are excluded from the definition of security in Section 102(28). In this definition, the term advisors does not mean investment advisors, as defined in Section 102(15). With respect to employee benefit plans that are securities, Section 202(21) provides an exemption, but follows RUSA in not limiting the exemption to investment contracts and not requiring 30 days notice to the administrator. Section 202(21) is modeled, in part, on Rule 701(c), adopted under the Securities Act of 1933. Compliance with Rule 701 will provide compliance with this exemption. Both the 1956 Act and RUSA, for unstated reasons, treated employee benefit plans as exempt securities, rather than exempt securities transactions. There appears to be no appropriate reason to do so. Resale of employee benefit plan securities can occur under appropriate Section 202 transaction exemptions. Section 202(21) is not intended to provide a new method of publicly issuing securities. The administrator, when appropriate, can deny, condition, limit, or revoke an exemption under Section 202(21). See Section 204. 23 Section 202(22) Specified dividends and tender offers and judicially recognized reorganizations, prior provision, 1956 Act Section 401, J, 6, B, and D, RUSA Section 101, 13, 6. Section 202(22), A, and B, generally follow exclusions from the definition of sale in the 1956 Act and RUSA. Section 202(22), C, is new and corresponds to Rule 162, recently adopted under the Securities Act of 1933, which allows the offerer in a stock exchange offer to solicit tenders of securities before a registration statement is effective as long as no securities are purchased until the registration statement is effective and the tender offer has expired. 24 Section 202(23) Non-issue or transactions involving specified foreign issuer securities traded on designated securities exchanges. This exemption expressly covers Toronto Stock Exchange issuers that are public reporting companies under Canadian securities law and meet the 180-day continuous reporting requirement. In conformance with the North American Free Trade Agreement, NAFTA, and General Agreement on Trade in Services, GATS, the exemption separately provides authority for the administrator to designate by rule or order other specific foreign jurisdictions and their trading exchanges upon an adequate showing. The exemption also provides authority for an administrator to revoke any designation if necessary or appropriate in the public interest and for the protection of investors. 60 Section 203. Additional exemptions and waivers. A rule adopted or order issued under this Act may exempt a security, transaction, or offer. A rule under this Act may exempt a class of securities, transactions, or offers from any or all of the requirements of Sections 301 through 306 and 504, and an order under this Act may waive, in whole or in part, any or all of the conditions for an exemption or offer under Sections 201 and 202. Official comments prior provision, RUSA Section 403. 1. Under this type of authority, 50 of 53 jurisdictions through September 2002 had adopted the Uniform Limited Offering Exemption, ULOE, or a Regulation D exemption, and 32 jurisdictions had adopted a Rule 144A exemption. This Act does not incorporate ULOE or a Rule 144A exemption because of their complexity and the likelihood of periodic updating of their provisions. Rule 144A, and similar exemptions in ULOE, can be most effectively implemented by rule rather than statute. 2. Under Section 203, a state would also be authorized to adopt by rule or order new exemptions as circumstances warrant for new technologies such as the Internet. Cf. NASAA Resolution regarding securities offered on Internet, NASAA Republic 7040, January 7, 1996. 3. It is the intent of this section that ULOE, Rule 144A, and additional exemptions or waivers be adopted uniformly by states, to the extent this is practicable. Section 204. Denial, suspension, revocation, condition, or limitation of exemptions. A. Enforcement-related powers. Except with respect to a federal covered security or a transaction involving a federal covered security, an order under this Act may deny, suspend application of, condition, limit, or revoke an exemption created under Section 201, 3, C, 7, or 8, or 202, or an exemption or waiver created under Section 203 with respect to a specific 61 security, transaction, or offer. An order under this section may be issued only pursuant to the procedures in Section 306, D, or 604 and only prospectively. B. Knowledge of order required. A person does not violate Section 301, 303 through 306, 504, or 510 by an offer to sell, offer to purchase, sale, or purchase effected after the entry of an order issued under this section if the person did not know, and in the exercise of reasonable care could not have known, of the order. Official comments prior provisions, 1956 Act Section 402, C, RUSA Section 404. 1. Section 204 is potentially far-reaching. The ability to deny, condition, limit, or revoke the exemptions specified in Sections 201, 3, C, 201, 7, 201, 8, 202, or 203 is adopted concomitant with the breadth of these exemptions. One or more than one security, transaction, or offer can be covered by a Section 204 order. 2. The courts have given a securities administrator's decision to deny or revoke an exemption substantial deference when there was compliance with applicable due process and statutory requirements. C. E.g., Johnson Bolesco, Inc. v. Div of Seconds, 829 p.2 d 101, Utah CTF 1992. 62 Article 3 Registration of Securities and Notice Filing of Federal Covered Securities Section 301. Securities Registration Requirement. It is unlawful for a person to offer or sell a security in this state unless, 1. The security is a federal covered security, 2. The security, transaction, or offer is exempted from registration under Sections 201 through 203, or, 3. The security is registered under this Act. Official comments prior provisions, 1956 Act Section 301, RUSA Section 301. 1. This section is substantively identical to the 1956 Act and RUSA except for the addition of Section 301, 1, which is necessitated by the National Securities Markets Improvement Act of 1996. See Section 102, 7. 2. Except for federal covered securities, exempt securities, or securities offered or sold in exempt transactions, no sale of a security may be made in the state before the security is registered. Sale is defined in Section 102, 26, in this state is addressed in Section 610, and securities registration is addressed in Sections 303 through 306. 3. The Securities Act of 1933 permits certain types of offers during the waiting period between the filing and effectiveness of a registration statement. The exemptive provisions of Sections 202, 16, and 17 operate to permit similar offers for securities that are not federal covered securities and are in the process of registration under federal or state statutes or both. 4. Notice filings and fees applicable to federal covered securities, see Section 102, 7, are addressed in Section 302. 63. Section 302. Notice filing. A. Required filing of records. With respect to a federal covered security, as defined in Section 18, b. 2, of the Securities Act of 1933, 15 U.S.C. Section 77R, b. 2, that is not otherwise exempt under Sections 201 through 203, a rule adopted or order issued under this Act may require the filing of any or all of the following records: 1. Before the initial offer of a federal covered security in the state, all records that are part of a federal registration statement filed with the Securities and Exchange Commission under the Securities Act of 1933 and a consent to service of process complying with Section 611 signed by the issuer and the payment of a fee of $_____. 2. After the initial offer of the federal covered security in the state, all records that are part of an amendment to a federal registration statement filed with the Securities and Exchange Commission under the Securities Act of 1933, and 3. To the extent necessary or appropriate to compute fees, a report of the value of the federal covered securities sold or offered to persons present in the state, if the sales data are not included in records filed with the Securities and Exchange Commission, and payment of a fee of $____. B. Notice filing effectiveness and renewal. A notice filing under subsection A is effective for 1 year commencing on the later of the notice filing or the effectiveness of the offering filed with the Securities and Exchange Commission. On or before expiration, the issuer may renew a notice filing by filing a copy of those records filed by the issuer with the Securities and Exchange Commission that are required by rule or order under this Act to be filed, and by paying a renewal fee of $____. A previously filed consent to service of process complying with 64 Section 611 may be incorporated by reference in a renewal. A renewed notice filing becomes effective upon the expiration of the filing being renewed. C. Notice filings for federal covered securities under Section 18, b. 4, d. With respect to a security that is a federal covered security under Section 18, b. 4, d. of the Securities Act of 1933, 15 U.S.C. Section 77R, b. 4, d. A rule under this Act may require a notice filing by or on behalf of an issuer to include a copy of Form D, including the appendix, as promulgated by the Securities and Exchange Commission, and a consent to service of process complying with Section 611 signed by the issuer not later than 15 days after the first sale of the federal covered security in the state, and the payment of a fee of $_____, and the payment of a fee of $_____ for any late filing. D. Stop orders. Except with respect to a federal security under Section 181, b. 1, of the Securities Act of 1933, 15 U.S.C. Section 77R, b. 1, if the administrator finds that there is a failure to comply with a notice or fee requirement of this section, the administrator may issue a stop order suspending the offer and sale of a federal covered security in the state. If the deficiency is corrected, the stop order is void as of the time of its issuance, and no penalty may be imposed by the administrator. Official comments. No prior provision 1. The little-used registration by notification in the 1956 Act Section 302 or registration by filing in RUSA Section 302 are omitted from this Act because of the notice filing approach required by Section 18, b. 2, of the Securities Act of 1933 for federal covered securities, which, in essence, replaces the need for registration by notification. 2. For Rule 506 offerings which are addressed by Section 18, d. 4, d. of the Securities Act of 1933, the Securities and Exchange Commission requires the filing of Form D. See Rule 503. 65. When an issuer meets the conditions of Rule 506, Section 302, c. is intended to limit required state filings to no more than a requirement of filing a copy of Form D, including the appendix, a consent to service of process, and a fee. 3. The definition of filing in Section 102(8) will permit states to receive electronic filing of records under this section. An administrator may also accept under the section assigned consent filed electronically with a designee of the administrator. See Section 105. 4. If a state prefers to have the fees in this section established by rule, replace the phrase of fee of $____ in subsections A, B, and C, with the phrase of fee established by the administrator by rule. See Comment 3 to Section 410. Section 303. Securities registration by coordination. A. Registration permitted. A security for which a registration statement has been filed under the Securities Act of 1933 in connection with the same offering may be registered by coordination under this section. B. Required records. A registration statement and accompanying records under this section must contain or be accompanied by the following records in addition to the information specified in Section 305 and a consent to service of process complying with Section 611. 1. A copy of the latest form of prospectus filed under the Securities Act of 1933. 2. A copy of the Articles of Incorporation and bylaws or their substantial equivalents currently in effect, a copy of any agreement with or among underwriters, a copy of any indenture or other instrument governing the issuance of the security to be registered, and a specimen, copy, or description of the security that is required by rule adopted or order issued under this Act. 3. Copies of any other information or any other records filed by the issuer under the Securities Act of 1933 requested by the administrator, and 4. An undertaking to forward each amendment to the federal prospectus, other than 66 an amendment that delays the effective date of the registration statement, promptly after it is filed with the Securities and Exchange Commission. C. Conditions for effectiveness of registration statement. A registration statement under this section becomes effective simultaneously with or subsequent to the federal registration statement when all the following conditions are satisfied. 1. A stop order under subsection D, or Section 306 or issued by the Securities and Exchange Commission is not in effect and a proceeding is not pending against the issuer under Section 412, and 2. The registration statement has been on file for at least 20 days or a shorter period provided by rule adopted or order issued under this Act. D. Notice of Federal Registration Statement Effectiveness. The registrant shall promptly notify the administrator in a record of the date when the federal registration statement becomes effective and the content of any price amendment and shall promptly file a record containing the price amendment. If the notice is not timely received, the administrator may issue a stop order, without prior notice or hearing, retroactively denying effectiveness to the registration statement or suspending its effectiveness until compliance with this section. The administrator shall promptly notify the registrant of an order by telegram, telephone, or electronic means and promptly confirm this notice by a record. If the registrant subsequently complies with the notice requirements of this section, the stop order is void as of the date of its issuance. E. Effectiveness of registration statement. If the federal registration statement becomes effective before each of the conditions in this section is satisfied or is waived by the administrator, The registration statement is automatically effective under this Act when all the 67 conditions are satisfied or waived. If the registrant notifies the administrator of the date when the federal registration statement is expected to become effective, the administrator shall promptly notify the registrant by telegram, telephone, or electronic means and promptly confirm this notice by a record, indicating whether all the conditions are satisfied or waived and whether the administrator intends the institution of a proceeding under Section 306. The notice by the administrator does not preclude the institution of such a proceeding. Official comments. Prior provisions, 1956 Act Section 303, RUSA Section 303. 1. Registration by coordination was one of the key innovations of the 1956 Act. As in the 1956 Act, Section 303 streamlines the content of the registration statement and the procedure by which a registration statement becomes effective, but not the substantive standards governing the effectiveness of a registration statement. 2. The phrase "in connection with the same offering" in Section 303 does not require that the federal and state registration statements be filed simultaneously or become effective simultaneously. A registration by coordination can be filed in a state after the effectiveness of the federal registration statement as long as the administrator does not conclude that the interval was too long to consider the state registration statement the same offering. 3. Section 303 is similar to the 1956 Act except that these provisions have been modernized to include electronic filing and electronic notification. Cf. Sections 102, 8, 102, 25, 100, and 5. It is anticipated that this will facilitate simultaneous filing with the Securities and Exchange Commission and the states, which is consistent with the uniformity intended by this Act. Simultaneous or sequential filing could be administered through a designee similar to the current WebCRD or in conjunction with the Securities and Exchange Commission's Electronic Data Gathering, Analysis, and Retrieval (EDGAR) system or otherwise. 4. Section 303(b) is not intended to limit the administrator to requiring only the information and records filed with the Securities and Exchange Commission. 5. Sections 303(c) through (e) describe the conditions to be satisfied to achieve effectiveness of a coordinated filing. Price amendment is defined in Section 102(23). The administrator retains the right to test the registration statement by the substantive standards of Section 306(a), and may issue a stop or denial order if the administrator believes any of those provisions are applicable. 68. Section 304. Securities registration by qualification. A. Registration permitted. A security may be registered by qualification under this section. B. Required records. A registration statement under this section must contain the information or records specified in Section 305, a consent to service of process complying with Section 611, and, if required by rule adopted under this Act, the following information or records: 1. With respect to the issuer and any significant subsidiary, its name, address, and form of organization, the state or foreign jurisdiction and date of its organization, the general character and location of its business, a description of its physical properties and equipment, and a statement of the general competitive conditions in the industry or business in which it is or will be engaged. 2. With respect to each director and officer of the issuer, and other person having a similar status or performing similar functions, the person's name, address, and principal occupation for the previous 5 years, the amount of securities of the issuer held by the person as of the 30th day before the filing of the registration statement, the amount of the securities covered by the registration statement to which the person has indicated an intention to subscribe, and a description of any material interest of the person in any material transaction with the issuer or a significant subsidiary affected within the previous 3 years or proposed to be affected. 3. With respect to persons covered by paragraph 2, the aggregate sum of the remuneration paid to those persons during the previous 12 months and estimated to be paid 69. During the next 12 months, directly or indirectly, by the issuer, and all predecessors, parents, subsidiaries, and affiliates of the issuer. 4. With respect to a person owning of record or owning beneficially, if known, 10% or more of the outstanding shares of any class of equity security of the issuer, the information specified in paragraph 2, other than the person's occupation. 5. With respect to a promoter, if the issuer was organized within the previous 3 years, the information or records specified in paragraph 2, any amount paid to the promoter within that period or intended to be paid to the promoter, and the consideration for the payment. 6. With respect to a person on whose behalf any part of the offering is to be made in a nonisu or distribution, the person's name and address, the amount of securities of the issuer held by the person as of the date of the filing of the registration statement, a description of any material interest of the person in any material transaction with the issuer or any significant subsidiary affected within the previous 3 years or proposed to be affected, and a statement of the reasons for making the offering. 7. The capitalization and long-term debt, on both a current and pro forma basis, of the issuer and any significant subsidiary, including a description of each security outstanding or being registered or otherwise offered, and a statement of the amount and kind of consideration, whether in the form of cash, physical assets, services, patents, goodwill, or anything else of value, for which the issuer or any subsidiary has issued its securities within the previous 2 years or is obligated to issue its securities. 8. The kind and amount of securities to be offered, the proposed offering price or the method by which it is to be computed, any variation at which a proportion of the offering is to be 70 made to a person or class of persons other than the underwriters, with a specification of the person or class, the basis on which the offering is to be made if otherwise than for cash, the estimated aggregate underwriting and selling discounts or commissions and finder's fees, including separately cash, securities, contracts, or anything else of value to accrue to the underwriters or finders in connection with the offering or, if the selling discounts or commissions are variable, the basis of determining them and their maximum and minimum amounts, the estimated amounts of other selling expenses, including legal, engineering, and accounting charges, the name and address of each underwriter and each recipient of a finder's fee, a copy of any underwriting or selling group agreement under which the distribution is to be made or the proposed form of any such agreement whose terms have not yet been determined, and a description of the plan of distribution of any securities that are to be offered otherwise than through an underwriter. 9. The estimated monetary proceeds to be received by the issuer from the offering, the purposes for which the proceeds are to be used by the issuer, the estimated amount to be used for each purpose, the order or priority in which the proceeds will be used for the purposes stated, the amounts of any funds to be raised from other sources to achieve the purposes stated, the sources of the funds, and, if a part of the proceeds is to be used to acquire property, including goodwill, otherwise than in the ordinary course of business, the names and addresses of the vendors, the purchase price, the names of any persons that have received commissions in connection with the acquisition, and the amounts of the commissions and other expenses in connection with the acquisition, including the cost of borrowing money to finance the acquisition. 10. A description of any stock options or other security options outstanding, or to be 71 created in connection with the offering, and the amount of those options held or to be held by each person required to be named in paragraph 2, 4, 5, 6, or 8, and by any person that holds or will hold 10% or more in the aggregate of those options. 11. The dates of, parties to, and general effect concisely stated of each managerial or other material contract made or to be made otherwise than in the ordinary course of business to be performed in whole or in part at or after the filing of the registration statement or that was made within the previous 2 years, and a copy of the contract. 12. A description of any pending litigation, action, or proceeding to which the issuer is a party and that materially affects its business or assets, and any litigation, action, or proceeding known to be contemplated by governmental authorities. 13. A copy of any prospectus, pamphlet, circular, form letter, advertisement, or other sales literature intended as of the effective date to be used in connection with the offering, and any solicitation of interest used in compliance with Section 202, 17, b. 14, a specimen or copy of the security being registered, unless the security is uncertificated, a copy of the issuer's articles of incorporation and bylaws or their substantial equivalents, in effect, and a copy of any indenture or other instrument covering the security to be registered. 15. A signed or conformed copy of an opinion of counsel concerning the legality of the security being registered, with an English translation if it is in a language other than English, which states whether the security when sold will be validly issued, fully paid, and known assessable, and, if a debt security, a binding obligation of the issuer. 16. A signed or conformed copy of a consent of any accountant, engineer, appraiser, 72 or other person whose profession gives authority for a statement made by the person, if the person is named as having prepared or certified a report or valuation, other than an official record, that is public, which is used in connection with the registration statement. 17. A balance sheet of the issuer as of a date within 4 months before the filing of the registration statement, a statement of income and changes in financial position for each of the 3 fiscal years preceding the date of the balance sheet and for any period between the close of the immediately previous fiscal year and the date of the balance sheet, or for the period of the issuer's and any predecessor's existence if less than 3 years, and, if any part of the proceeds of the offering is to be applied to the purchase of a business, the financial statements that would be required if that business were the registrant, and, 18, any additional information or records required by rule adopted or order issued under this Act. C. Conditions for effectiveness of registration statement. A registration statement under this section becomes effective 30 days, or any shorter period provided by rule adopted or order issued under this Act, after the date the registration statement or the last amendment other than a price amendment is filed, if 1. A stop order is not in effect and a proceeding is not pending under Section 306, 2. The administrator has not issued an order under Section 306 delaying effectiveness, and 3. The applicant or registrant has not requested that effectiveness be delayed. D. Delay of effectiveness of registration statement. The administrator may delay effectiveness once for not more than 90 days if the administrator determines the registration 73 statement is not complete in all material respects and promptly notifies the applicant or registrant of that determination. The administrator may also delay effectiveness for a further period of not more than 30 days if the administrator determines that the delay is necessary or appropriate. E. Prospectus distribution may be required. A rule adopted or order issued under this Act may require as a condition of registration under this section that a prospectus containing a specified part of the information or record specified in subsection B be sent or given to each person to which an offer is made, before or concurrently, with the earliest of 1. The first offer made in a record to the person otherwise than by means of a public advertisement, by or for the account of the issuer or another person on whose behalf the offering is being made, or by an underwriter or broker-dealer that is offering part of an unsold allotment or subscription taken by the person as a participant in the distribution. 2. The confirmation of a sale made by or for the account of the person. 3. Payment pursuant to such a sale, or 4. Delivery of the security pursuant to such a sale. Official comments. Prior provisions, 1956 Act Section 304, RUSA Section 304. 1. This section generally follows the 1956 Act and RUSA. Any security may be registered by qualification, whether or not another type of registration is available. Ordinarily, however, registration by qualification will only be used by an issuer when no other procedure is available. 2. Section 304, b. Originally was modeled on Schedule A of the Securities Act of 1933. 3. In Section 304, b. 12, pending litigation can include litigation that has not yet been filed. 4. Section 304, b. 17, uses the same terminology as is used currently in Regulation SX of the Securities and Exchange Commission. Under Section 605, A, and C, the administrator is authorized to specify the form and content of rules and forms governing registration statements 74 and the form and content of financial statements required under this Act. 5. Under Sections 304, B, 18, and 307 the administrator may require additional information or may waive in whole or in part or condition any of the requirements of Section 304, B. Section 304, B, 18, for example, would authorize the administrator to require that a report by an accountant, engineer, appraiser, or other professional person be filed. Section 304, B, 18, would also authorize that securities of designated classes under a trust indenture contain additional specified information. Section 305. Securities registration filings. A. Who may file? A registration statement may be filed by the issuer, a person on whose behalf the offering is to be made, or a broker-dealer registered under this Act. B. Filing fee. A person filing a registration statement shall pay a filing fee of $___. If a registration statement is withdrawn before the effective date or a prefective stop order is issued under Section 306, the administrator shall retain $____ of the fee. C. Status of offering. A registration statement filed under Section 303 or 304 must specify, 1. The amount of securities to be offered in the state, 2. The states in which a registration statement or similar record in connection with the offering has been or is to be filed, and 3. Any adverse order, judgment, or decree issued in connection with the offering by a state securities regulator, the Securities and Exchange Commission, or a court. D. Incorporation by reference. A record filed under this Act or the predecessor Act within 5 years preceding the filing of a registration statement may be incorporated by reference in the registration statement to the extent that the record is currently accurate. 75. E. Non-issue or distribution. In the case of a non-issue or distribution, information, or a record may not be required under subsection I, or Section 304, unless it is known to the person filing the registration statement or to the person on whose behalf the distribution is to be made or unless it can be furnished by those persons without unreasonable effort or expense. F. Escrow and impoundment. A rule adopted or order issued under this Act may require as a condition of registration that a security issued within the previous 5 years or to be issued to a promoter for a consideration substantially less than the public offering price or to a person for a consideration other than cash be deposited in escrow, and that the proceeds from the sale of the registered security in the state be impounded until the issuer receives a specified amount from the sale of the security either in this state or elsewhere. The conditions of any escrow or impoundment required under this subsection may be established by rule adopted or order issued under this Act, but the administrator may not reject a depository institution solely because of its location in another state. G. Form of subscription. A rule adopted or order issued under this Act may require as a condition of registration that a security registered under this Act be sold only on a specified form of subscription or sale contract and that a signed or conformed copy of each contract be filed under this Act or preserved for a period specified by the rule or order, which may not be longer than 5 years. H. Effective period. Except while a stop order is in effect under Section 306, a registration statement is effective for 1 year after its effective date, or for any longer period designated in an order under this Act during which the security is being offered or distributed in a non-exempt transaction by or for the account of the issuer or other person on whose behalf the 76 offering is being made or by an underwriter or broker-dealer that is still offering part of an unsold allotment or subscription taken as a participant in the distribution. For the purposes of a non-issue or transaction, all outstanding securities of the same class identified in the registration statement as a security registered under this Act are considered to be registered while the registration statement is effective. If any securities of the same class are outstanding, a registration statement may not be withdrawn until 1 year after its effective date. A registration statement may be withdrawn only with the approval of the administrator. I. Periodic reports. While a registration statement is effective, a rule adopted or order issued under this Act may require the person that filed the registration statement to file reports, not more often than quarterly, to keep the information or other record in the registration statement reasonably current and to disclose the progress of the offering. J. Post-effective amendments. A registration statement may be amended after its effective date. The post-effective amendment becomes effective when the administrator so orders. If a post-effective amendment is made to increase the number of securities specified to be offered or sold, the person filing the amendment shall pay a registration fee of $__. A post-effective amendment relates back to the date of the offering of the additional securities being registered if, within 1 year after the date of the sale, the amendment is filed and the additional registration fee is paid. Official comments. Prior provisions, 1956 Act Section 305, RUSA Section 305. 1. Section 305 generally follows the 1956 Act and RUSA except that earlier provisions in both acts referring to Investment Company Act of 1940 securities, which are federal covered securities, see Section 102, 7, have been deleted. 77.2. Section 305 is applicable both to registration by coordination, see Section 303, and to registration by qualification, see Section 304. 3. Section 305, a, expressly authorizes registration by a person on whose behalf the offering is to be made. This would permit a non-issuer, cf. Section 102, 18, or a broker-dealer to file a registration statement independent of the issuer. 4. This Act is intended, to the extent practicable, to be revenue neutral in its impact on existing state law, see Comment 3 to Section 608. Accordingly, Section 305, b, does not specify what fees states should provide. If a state prefers to have the fees in this section established by rule, replace the phrase of fee of $____ in subsections b and j with the phrase of fee established by the administrator by rule pursuant to the State Administrative Procedure Act and replace the phrase $____ of the fee in subsection b with the phrase an amount of the fee established by the administrator by rule. See Comment 3 to Section 410. 5. Section 305, c, which generally follows the 1956 Act and RUSA, does not require in Section 305, c, 3, disclosure of an order permitting the withdrawal of a registration statement. The administrator may, however, require disclosure of this information in a registration by qualification under Section 304, b, 18. 6. Section 305, c, like every other provision concerned with the content of the registration statement, must be read with Section 306, a, 1, which judges the accuracy and completeness of the registration statement as of its effective date unless an order denying effectiveness had been entered before the effective date. A registration statement must be kept current with changing developments until the effectiveness date, but a registration statement is not required to be amended after the effective date except to correct inaccuracies or deficiencies which existed as of the effective date. An administrator, however, separately may require under Section 305, I, or j, periodic reports or amendments to keep reasonably current the information contained in the registration statement. 7. Under Section 305, d, incorporation by reference is permitted as a matter of administrative practice. 8. Section 305, e, is the substantive equivalent to provisions in the 1956 Act and RUSA. This subsection is designed to address non-issuer offerings where the seller cannot obtain certified financial statements and other normally required records. The phrase without unreasonable effort or expense originated in Section 10, a, 3, of the Securities Act of 1933. It is not meant to apply to expenses incidental to supplying required information required for registration in the case of a non-issue or distribution by a person in a control relationship with the issuer or otherwise having access to or contractual rights to obtain the required information. Section 305(e) applies only to registration by qualification under Section 304 and periodic reports for either registration by coordination or registration by qualification under Section 305(I). 78(9). Section 305(f) follows the 1956 Act and RUSA, and authorizes the administrator to require the impoundment of funds until the issuer receives a specified amount from the sale of the security in the state or elsewhere, and to require the escrow of promotional stock until specific conditions are met. This section is limited to a security issued within the past 5 years or to be issued to a promoter for a consideration substantially different from the public offering price or to a person for a consideration other than cash. The typical distribution subject to Section 305(f) will be a relatively new promotional or speculative offering. Section 305(f) follows the 1956 Act and RUSA and provides that the administrator may not reject a depository solely because of its location in another state. Unlike the statute in Schweiamal-Constant v. Michigan DEPT of Commerce, 360 N.W.2 D141, Michigan 1984, Section 305(f) broadly provides that the administrator may determine the conditions of any escrow or impoundment under this subsection. As in Schweiamal, this power will operate only until the impounded funds or escrowed shares are released. 10. Section 305(g) follows the 1956 Act in authorizing the administrator to specify the form of a subscription or sale contract. 11. Section 305(h) generally follows the 1956 Act and RUSA. The term non-issue transaction or non-issue distribution is defined in Section 102(18). A sale by a non-issue would have to be registered under Section 301 unless it is exempted or involves a federal covered security. Section 202(1) exempts isolated non-issue transactions. When a non-issue transaction is not exempt under Section 202(1), it may still be exempted under other transaction exemptions. If no exemption is available for a non-issue distribution, and it does not involve a federal covered security, the security must be registered under Article 3. Under the first sentence of Section 305(h), each registration statement remains effective for at least 1 year, and for any longer period the administrator may determine. However, no registration statement is effective while a stop order with respect to it is in effect under Section 306. For the purposes of a non-issue transaction, all outstanding securities of the same class as a registered security are considered to be registered as long as the registration statement remains effective. This means that during the effective period of a registration statement under this Act, all outstanding securities of the same class can be traded by anyone, including non-issuers, as if they were registered. Section 305(h) also provides that, unless the administrator determines otherwise, a registration statement cannot be withdrawn until 1 year after its effective date if any securities of the same class are outstanding. This is designed to protect sellers who would be unaware of a withdrawal from being subject to civil liability. 12. Section 305(j) follows RUSA and a procedure limited to investment companies in the 1956 Act in allowing post-effective date amendments. Under Section 305(j), when a post-effective 79 amendment increases the number of securities to be offered or sold, an additional registration fee is required. Section 306. Denial, suspension, and revocation of securities registration. A. Stop orders. The administrator may issue a stop order denying effectiveness to, or suspending or revoking the effectiveness of, a registration statement if the administrator finds that the order is in the public interest and that, 1. The registration statement as of its effective date or before the effective date in the case of an order denying effectiveness, an amendment under Section 305(j), as of its effective date, or a report under Section 305(i), is incomplete in a material respect or contains a statement that, in the light of the circumstances under which it was made, was false or misleading with respect to a material fact. 2. This act or a rule adopted or order issued under this act or a condition imposed under this act has been willfully violated, in connection with the offering, by the person filing the registration statement, by the issuer, a partner, officer, or director of the issuer or a person having a similar status or performing a similar function, a promoter of the issuer, or a person directly or indirectly controlling or controlled by the issuer, but only if the person filing the registration statement is directly or indirectly controlled by or acting for the issuer, or by an underwriter. 3. The security registered or sought to be registered is the subject of a permanent or temporary injunction of a court of competent jurisdiction or an administrative stop order or a similar order issued under any federal, foreign, or state law other than this act, applicable to the offering, but the administrator may not institute a proceeding against an effective registration statement under this paragraph more than 1 year after the date of the order or injunction on which it is based, and the administrator may not issue an order under this paragraph on the basis of an order or injunction issued under the Securities Act of another state unless the order or injunction was based on conduct that would constitute, as of the date of the order, a ground for a stop order under this section. 4. The issuer's enterprise or method of business includes or would include activities that are unlawful where performed. 5. With respect to a security sought to be registered under Section 303, there has been a failure to comply with the undertaking required by Section 303, b. 4. 6. The applicant or registrant has not paid the filing fee, but the administrator shall void the order if the deficiency is corrected, or 7. The offering, a. will work or tend to work a fraud upon purchasers or would so operate, or b. has been or would be made with unreasonable amounts of underwriters and sellers discounts, commissions, or other compensation, or promoters' profits or participations, or unreasonable amounts or kinds of options, or c. is being made on terms that are unfair, unjust, or inequitable. b. Enforcement of subsection a. 7. To the extent practicable, the administrator by rule adopted or order issued under this act shall publish standards that provide notice of conduct that violates subsection a. 7. 81. C. Institution of stop order. The administrator may not institute a stop order proceeding against an effective registration statement on the basis of conduct or a transaction known to the administrator when the registration statement became effective unless the proceeding is instituted within 30 days after the registration statement became effective. D. Summary process. The administrator may summarily revoke, deny, postpone, or suspend the effectiveness of a registration statement pending final determination of an administrative proceeding. Upon the issuance of the order, the administrator shall promptly notify each person specified in subsection e. that the order has been issued, the reasons for the revocation, denial, postponement, or suspension, and that within 15 days after the receipt of a request in a record from the person the matter will be scheduled for a hearing. If a hearing is not requested and none is ordered by the administrator, within 30 days after the date of service of the order becomes final. If a hearing is requested or ordered, the administrator, after notice of an opportunity for hearing for each person subject to the order, may modify or vacate the order or extend the order until final determination. E. Procedural requirements for stop order. A stop order may not be issued under this section without 1. Appropriate notice to the applicant or registrant, the issuer, and the person on whose behalf the securities are to be or have been offered. 2. An opportunity for hearing, and 3. Findings of fact and conclusions of law in a record in accordance with the State Administrative Procedure Act. F. Modification or vacation of stop order. The administrator may modify or vacate a 82 stop order issued under this section if the administrator finds that the conditions that caused its issuance have changed or that it is necessary or appropriate in the public interest or for the protection of investors. Official comments. Prior provisions, 1956 Act Section 306, RUSA Section 306. 1. This section generally follows the 1956 Act and RUSA and applies to both registration by coordination under Section 303 and registration by qualification under Section 304. 2. Section 306, a. 1, follows the 1956 Act and RUSA in testing in a suspension or revocation preceding the completeness and accuracy of a registration statement as of the registration statement's effective date. A registration statement that becomes misleading because of a development that occurs after its effective date is not a ground for the issuance of a stop order under Section 306, a. 1. An administrator, however, may require periodic reports under Section 305, I, or a post-effective amendment under Section 305, J. With respect to periodic reports under Section 305, I, a misleading report would be the basis of a stop order under Section 306, a. 1, if it is materially inaccurate as of the date it was filed. 3. On the meaning of willfully, see Comment 2 under Section 508. 4. A violation by an issuer has the same consequences whether the issuer has filed a registration statement or has had a broker-dealer file it. But this is not the case when the registration statement is filed by a broker-dealer acting independently. 5. The verb is at the beginning of Section 306, a. 3, means that a stop order or injunction that has expired or been vacated is not the ground for action under this paragraph. 6. Section 306, a. 4, applies to activity that is conducted in a state where that activity is illegal. It does not apply if the activity is not illegal under that state's law. This paragraph is not meant to apply to activity which is lawful where conducted but would be illegal if conducted in the state where the registration statement is filed. 7. Sections 306, a. 5, and 6, follow the 1956 Act and RUSA. 8. Sections 306, a. 7, and b. address merit regulation. Sections 306, e, and f, of the 1956 Act authorized a stop order when an offering has worked or tended to work a fraud upon purchasers or would so operate or the offering has been or would be made with unreasonable amounts of underwriters and sellers' discounts, commissions, or other compensation, or promoters' profits or participation, or unreasonable amounts or kinds of options. By 1985-83 majority of states which had adopted the 1956 Act had adopted this approach to merit regulation rather than the earlier and broader unfair, unjust, or inequitable standard that then applied in a minority of states. RUSA Sections 306, a. 5, and 6, adopted provisions substantively identical to the 1956 Act and included in brackets an unfair, unjust, or inequitable alternative. The National Securities Markets Improvement Act of 1996 subsequently preempted merit regulation of federal covered securities. See Section 102, 7. Sections 306, a, 7, and b, take a different approach. Subject to the National Securities Markets Improvement Act of 1996, merit standards are retained but hortatory paragraph 306, b, encourages the administrator, to the extent practicable, to adopt, by rule or order, standards that provide notice to issuers of a state's merit standards. Notice will address one criticism of merit regulation. See generally 1 Lewis Loss and Joel Seligman, Securities Regulation 111-124, 3D ed. Rev. 1998. Statements of policy of the North American Securities Administrator Association that have been adopted by a state would provide notice in compliance with Section 306, b. Similarly, other state rules or orders could be adopted in the future to address new types of securities as they occur. An order under Section 306, b, can be adopted after a securities registration statement has been filed. Under Section 306, b, an administrator, by rule or order, for example, could adopt a standard that would provide the basis for a stop order denying effectiveness to a development stage company that has no specific business purpose or plan or has indicated that its primary business plan is to engage in a merger or acquisition with an unidentified company, entity, or person. Blank check offerings are subject to Rule 419 adopted under the Securities Act of 1933. See Comment 3 to Section 202. 9. Section 306, c, follows the 1956 Act and RUSA and allows an administrator up to 30 days after a registration statement becomes effective to institute a stop order proceeding on the basis of a fact or transaction known when the registration statement became effective. This is to avoid the necessity of an administrator issuing a stop order prematurely. 10. Sections 306, d, and e, assure each person subject to a stop order of notice, opportunity for a hearing, and findings of fact and conclusions of law contained in a record. 11. An administrator must consider the public interest when issuing a stop order and may under Section 306, f, consider the public interest when modifying or vacating a stop order. C, e.g., Technomedical Lab, Inc. v. Utah Secretary DIB, 744p.2d 320, 324-325, Utah CT App 1987, a state has a valid public interest in stopping the issuance of hundreds of thousands of public shares that did not comply with the disclosure requirements of securities registration, cf. Stop orders under the Securities Act of 1933, C1 Lewis Loss and Joel Seligman, Securities Regulation 576589, 3D Ed Rev 1998. 8412. As of September 2002, 46 jurisdictions had adopted a form of Section 306, A, 7, A, will tend to work a fraud or would so operate. 34 jurisdictions had adopted a form of Section 306, A, 7, B, unreasonable amounts of underwriters and sellers discounts, commissions, or other compensation, or promoter profits or participations, or unreasonable amounts or kinds of options, and 16 jurisdictions had adopted a form of bracketed Section 306, A, 7, C, terms that are unfair, unjust, or inequitable. Section 307. Waiver and modification. The administrator may waive or modify, in whole or in part, any or all of the requirements of Sections 302, 303, and 304, b, or the requirement of any information or record in a registration statement or in a periodic report filed pursuant to Section 305, I. Official comments prior provision, RUSA Section 303, H. Section 307 follows RUSA Section 303, H, and empowers the administrator to waive or modify any of the requirements of 302, 303, 304, b, or the requirement of any information or record in a registration statement. An example would be the expedited procedure several states have adopted to coordinate with shelf registration under Rule 415 of the Securities Act of 1933. In waiving or modifying requirements, the administrator must make a finding satisfying the requirements of Section 605, b. 85 Article 4 Broker-dealers, agents, investment advisors, investment advisor representatives, and federal covered investment advisors Section 401. Broker-dealer registration requirement and exemptions. A. Registration requirement. It is unlawful for a person to transact business in the state as a broker-dealer unless the person is registered under this act as a broker-dealer or is exempt from registration as a broker-dealer under subsection B, or D. B. Exemptions from registration. The following persons are exempt from the registration requirement of subsection A. 1. A broker-dealer without a place of business in the state if its only transactions effected in the state are with A. The issuer of the securities involved in the transactions, B. A person registered as a broker-dealer under this act or not required to be registered as a broker-dealer under this act, C. An institutional investor, D. A non-affiliated federal covered investment advisor with investments under management in excess of $100 million acting for the account of others pursuant to discretionary authority in assigned record. 86. E. A bona fide pre-existing customer whose principal place of residence is not in the state and the person is registered as a broker-dealer under the Securities Exchange Act of 1934 or not required to be registered under the Securities Exchange Act of 1934 and is registered under the Securities Act of the state in which the customer maintains a principal place of residence. F. A bona fide pre-existing customer whose principal place of residence is in the state but was not present in the state when the customer relationship was established, if I. The broker-dealer is registered under the Securities Exchange Act of 1934 or not required to be registered under the Securities Exchange Act of 1934 and is registered under the securities laws of the state in which the customer relationship was established and where the customer had maintained a principal place of residence, and 2. Within 45 days after the customer's first transaction in the state, the person files an application for registration as a broker-dealer in the state and a further transaction is not effected more than 75 days after the date on which the application is filed, or, if earlier, the date on which the administrator notifies the person that the administrator has denied the application for registration or has stayed the pendency of the application. For good cause, g. Not more than 3 customers in the state during the previous 12 months, in addition to those customers specified in subparagraphs A through F, and under subparagraph H, if the broker-dealer is registered under the Securities Exchange Act of 1934 or not required to be registered under the Securities Exchange Act of 1934 and is registered under the Securities Act of the state in which the broker-dealer has its principal place of business, and H. Any other person exempted by rule adopted or order issued under this Act, and 2. A person that deals solely in United States government securities and is supervised as a 87 dealer in government securities by the Board of Governors of the Federal Reserve System, the Controller of the Currency, the Federal Deposit Insurance Corporation, or the Office of Thrift Supervision. C. Limits on employment or association. It is unlawful for a broker-dealer, or for an issuer engaged in offering to purchase, purchasing, or selling securities in the state, directly or indirectly, to employ or associate with an individual to engage in an activity related to securities transactions in the state if the registration of the individual is suspended or revoked or the individual is barred from employment or association with a broker-dealer, an issuer, an investment advisor, or a federal covered investment advisor by an order of the administrator under this Act, the Securities and Exchange Commission, or a self-regulatory organization. A broker-dealer or issuer does not violate this subsection if the broker-dealer or issuer did not know and in the exercise of reasonable care could not have known, of the suspension, revocation, or bar. Upon request from a broker-dealer or issuer and for good cause, an order under this Act may modify or waive, in whole or in part, the application of the prohibitions of this subsection to the broker-dealer. D. Foreign transactions. A rule adopted or order issued under this Act may permit, 1. A broker-dealer that is registered in Canada or other foreign jurisdiction and that does not have a place of business in the state to effect transactions in securities with or for, or attempt to effect the purchase or sale of any securities by, a. An individual from Canada or other foreign jurisdiction who is temporarily present in the state and with whom the broker-dealer had a bona fide customer relationship before the individual entered the United States. 88. B. An individual from Canada or other foreign jurisdiction who is present in the state and whose transactions are in a self-directed tax-advantaged retirement plan of which the individual is the holder or contributor in that foreign jurisdiction, or, c. An individual who is present in the state, with whom the broker-dealer customer relationship arose while the individual was temporarily or permanently resident in Canada or the other foreign jurisdiction, and 2. An agent who represents a broker-dealer that is exempt under this subsection to effect transactions in securities or attempt to effect the purchase or sale of securities in the state as permitted for a broker-dealer described in paragraph 1. Official comments. Prior provisions, 1956 Act Section 201, RUSA Sections 201 to 202. 1. Broker-dealer is defined in Section 102, 4. The scope of the Section 401, a. reference to transact business in the state is specified in Section 610. Transacts a business has been held to mean more than a trivial or de minimis business. United States v. Schwartz, 464 F.2d 499, 506, 2d Sir 1972, Cert. Denied, 409 U.S. 1009, 1972. 2. Under Section 401, a person can be required to register as a securities broker-dealer only if the person transacts business in securities. C. E.g., AMR Realty Co. v. State, 373 A.2d 1002, NJ Sapir CTFDIB 1977, requirement that the transactions involve securities. 3. Bona fide is a much construed term particularly in the UCC context. C. E.g., MCC Proceeds, Inc. v. Advest, Inc., 743 N.Y.S.2d1, NYAD 2002, comparing bona fide to good faith standard. 4. Section 401, b. 1, d, was added to provide relief in situations where a broker-dealer is accepting orders from a sophisticated financial professional who is making the investment decisions for its customers. 5. Under 401, b. 1, e, and f, pre-existing customers must be bona fide. A principal place of residence, for example, normally would be the residence where the customer spends a majority of time. These exemptions were intended to facilitate ongoing broker-customer relationships with customers who have established a second or other residence for such purposes as a winter home. 89, i.e. snowbirds. 6. Section 401, c, prohibits a broker-dealer or issuer from employing or associating with an individual in a capacity for which that individual has been suspended by the administrator. Violation of this provision does not result in strict liability. In order for a broker-dealer or issuer to be liable, the broker-dealer or issuer must have known or should have known of the administrator's order to the individual suspended or barred. Cf. Comment 17 to Section 412. 7. Section 401, d, recognizes the increasingly transnational nature of securities brokerage and permits, if the administrator adopts a rule or order, transactions by a Canadian or a foreign broker-dealer with a person from Canada or other foreign jurisdiction who is resident in the state. This subsection is not self-executing and is effective only if the administrator adopts a rule or order. 8. To give effect to action taken by rule or order under Section 401, d, there must be a transaction registration exemption that will enable securities transactions to take place in customer accounts involving the broker-dealers and agents contemplated in Section 401, d. See Sections 202 and 203. Section 402. Agent registration requirement and exemptions. A. Registration requirement. It is unlawful for an individual to transact business in the state as an agent unless the individual is registered under this Act as an agent or is exempt from registration as an agent under subsection B. B. Exemptions from registration. The following individuals are exempt from the registration requirement of subsection A. 1. An individual who represents a broker-dealer in effecting transactions in the state limited to those described in Section 15, H. 2, of the Securities Exchange Act of 1934, 15 U.S.C. Section 78, 2, 2, an individual who represents a broker-dealer that is exempt under Section 401, B, or D, 90, 3, an individual who represents an issuer with respect to an offer or sale of the issuer's own securities, or those of the issuer's parent or any of the issuer's subsidiaries, and who is not compensated in connection with the individual's participation by the payment of commissions or other remuneration based, directly or indirectly, on transactions in those securities. 4. an individual who represents an issuer and who effects transactions in the issuer's securities exempted by Section 202, other than Section 202, 11, and 14, 5, an individual who represents an issuer that effects transactions solely in federal covered securities of the issuer, but an individual who effects transactions in a federal covered security under Section 18, b. 3, or 18, b. 4, d, of the Securities Act of 1933, 15 U.S.C. Section 77R, b. 3, or 77R, b. 4, d, is not exempt if the individual is compensated in connection with the agent's participation by the payment of commissions or other remuneration based, directly or indirectly, on transactions in those securities. 6. An individual who represents a broker-dealer registered in the state under Section 401(a), or exempt from registration under Section 401(b), in the offer and sale of securities for an account of a non-affiliated federal covered investment advisor with investments under management in excess of $100 million acting for the account of others pursuant to discretionary authority in assigned record. 7. An individual who represents an issuer in connection with the purchase of the issuer's own securities. 8. An individual who represents an issuer and who restricts participation to performing clerical or ministerial acts, or 91. 9. Any other individual exempted by rule adopted or order issued under this Act. C. Registration effective only while employed or associated. The registration of an agent is effective only while the agent is employed by or associated with a broker-dealer registered under this Act or an issuer that is offering, selling, or purchasing its securities in this state. D. Limit on employment or association. It is unlawful for a broker-dealer, or an issuer engaged in offering, selling, or purchasing securities in the state, to employ or associate with an agent who transacts business in the state on behalf of broker-dealers or issuers unless the agent is registered under subsection A, or exempt from registration under subsection B. E. Limit on affiliations. An individual may not act as an agent for more than one broker-dealer or one issuer at a time, unless the broker-dealer or the issuer for which the agent acts are affiliated by direct or indirect common control or are authorized by rule or order under this Act. Official comments. Prior provisions, RUSA sections 201 to 202. One agent is defined in Section 102, 2. The scope of the Section 402(a) reference to transact business in the state is specified in Section 610. An administrator may by rule or order take action under Section 401(d) 2, to address an agent. 2. An independent contractor must be either a broker-dealer or an agent if the individual transacts business as a broker-dealer or agent. There is no other status permitted under this Act for securities activities. 3. A broker-dealer in violation of Section 402(a) may be disciplined under Section 412 and be subject to a civil or administrative enforcement action under Section 603 or 604. 4. Under Sections 402(b), 3, and 5, an agent may be exempt if acting for an issuer and receiving compensation, for example, as a corporate executive, as long as the compensation is 92 not a commission or other remuneration based on transactions in the issuer's own securities. Such an agent could receive a salary with conventional benefits, including an annual bonus, related to his or her performance, as an executive, and still be within this exemption unless the agent is also being compensated directly or indirectly for participation in the specified securities transactions. 5. Section 402(b) 6, was added to provide relief in situations where an agent is accepting orders from a sophisticated financial professional who is making the investment decisions for its customers. 6. Ministerial or clerical acts in Section 402(b) 8, might include preparing routine written communications or responding to inquiries. 7. Section 402(e) limits agents to a single employment or affiliation unless a rule or order of the administrator authorizes multiple affiliations. In any event, an agent must be registered, see Section 402(a). or exempt from registration, see Section 402, b. Registration is effective only while an agent is employed by or associated with a broker-dealer or an issuer. See Section 402, c. Section 403. Investment Advisor Registration Requirement and Exemptions. A. Registration Requirement. It is unlawful for a person to transact business in the state as an investment advisor unless the person is registered under this Act as an investment advisor or is exempt from registration as an investment advisor under subsection B. B. Exemptions from registration. The following persons are exempt from the registration requirement of subsection A. 1. A person without a place of business in the state that is registered under the Securities Act of the state in which the person has its principal place of business if its only clients in the state are A. Federal covered investment advisors registered under this 93 Act, or broker-dealers registered under this Act, B. Institutional investors, C. Bona fide pre-existing clients whose principal places of residence are not in the state if the investment advisor is registered under the Securities Act of the state in which the clients maintain principal places of residence, or D. Any other client exempted by rule adopted or order issued under this Act. 2. A person without a place of business in the state if the person has had, during the preceding 12 months, not more than 5 clients that are resident in the state in addition to those specified under paragraph 1. Or, 3, any other person exempted by rule adopted or order issued under this Act. C. Limits on employment or association. It is unlawful for an investment advisor, directly or indirectly, to employ or associate with an individual to engage in an activity related to investment advice in the state if the registration of the individual is suspended or revoked or the individual is barred from employment or association with an investment advisor, federal covered investment advisor, or broker-dealer by an order under this Act, the Securities and Exchange Commission, or a self-regulatory organization, unless the investment advisor did not know, and in the exercise of reasonable care could not have known, of the suspension, revocation, or bar. Upon request from the investment advisor and for good cause, the administrator, by order, may waive, in whole or in part, the application of the prohibitions of this subsection to the investment advisor. D. Investment advisor representative registration required. It is unlawful for an investment advisor to employ or associate with an individual required to be registered under this 94 Act as an investment advisor representative who transacts business in the state on behalf of the investment advisor unless the individual is registered under Section 404A, or is exempt from registration under Section 404B. Official comments. Prior provisions, 1956 Act Section 201, RUSA Sections 203 to 204. 1. Investment advisor is defined in Section 102(15). The scope of the Section 403A, reference to transact business in the state is specified in Section 610. 2. Excluded from the definition of investment advisor in Section 102(15) c. is a broker-dealer who receives no special compensation for investment advisory services. Such a broker-dealer would not have to register as both a broker-dealer and investment advisor in this state. A broker-dealer that does receive special compensation, on the other hand, would also meet the statutory definition of investment advisor and would be required to register in both capacities. 3. Section 403(b) 2, is consistent with the National Securities Markets Improvement Act of 1996, which prohibits a state from regulating an investment advisor that does not have a place of business in the state and had fewer than 6 clients who were state residents during the preceding 12 months. 4. Section 403(c) prohibits an investment advisor from employing an individual who is prohibited from such employment or association by the administrator. Violation of this provision does not result in strict liability. To be liable, the investment advisor must have known or should have known of the administrator's order to the individual suspended or barred. Section 404. Investment advisor representative registration requirement and exemptions. A. Registration requirement. It is unlawful for an individual to transact business in the state as an investment advisor representative unless the individual is registered under this Act as an investment advisor representative or is exempt from registration as an investment advisor under subsection B. 95, B. Exemptions from registration. The following individuals are exempt from the registration requirement of subsection A. 1. An individual who is employed by or associated with an investment advisor that is exempt from registration under Section 403, B, or a federal covered investment advisor that is excluded from the notice filing requirements of Section 405, and 2. Any other individual exempted by rule adopted or order issued under this Act. C. Registration effective only while employed or associated. The registration of an investment advisor representative is not effective while the investment advisor representative is not employed by or associated with an investment advisor registered under this Act or a federal covered investment advisor that has made or is required to make a notice filing under Section 405. D. Limit on affiliations. An individual may transact business as an investment advisor representative for more than one investment advisor or federal covered investment advisor unless a rule adopted or order issued under this Act prohibits or limits an individual from acting as an investment advisor representative for more than one investment advisor or federal covered investment advisor. E. Limits on employment or association. It is unlawful for an individual acting as an investment advisor representative, directly or indirectly, to conduct business in the state on behalf of an investment advisor or a federal covered investment advisor if the registration of the individual as an investment advisor representative is suspended or revoked or the individual is barred from employment or association with an investment advisor or a federal covered investment advisor by an order under this Act, the Securities and Exchange Commission, or a 96 self-regulatory organization. Upon request from a federal covered investment advisor and for good cause, the administrator, by order issued, may waive, in whole or in part, the application of the requirements of this subsection to the federal covered investment advisor. F. Referral fees. An investment advisor registered under this Act, a federal covered investment advisor that has filed a notice under Section 405, or a broker-dealer registered under this Act is not required to employ or associate with an individual as an investment advisor representative if the only compensation paid to the individual for a referral of investment advisory clients is paid to an investment advisor registered under this Act, a federal covered investment advisor who has filed a notice under Section 405, or a broker-dealer registered under this Act with which the individual is employed or associated as an investment advisor representative. Official comments. No prior provision. 1. Investment advisor representative is defined in Section 102(16). The scope of the Section 404(a) reference to transacts business in the state is specified in Section 610. 2. Neither the 1956 Act nor RUSA provided for the registration of investment advisor representatives. In recent years, however, the states increasingly have done so. 3. Under this Act a sole practitioner may register as an investment advisor. See Section 403. The Investment Advisor Registration Depository currently provides for entry of the legal name of the individual as the investment advisor and the entry of any name the individual is doing business under that is different from the individual's name. A sole practitioner is not required to register under Section 404 as an investment advisor representative, unless the administrator requires such registration. 4. Section 404(e) prohibits an investment advisor representative from association with a federal covered investment advisor when such association is prohibited by an order of the administrator. Unlike similar provisions in Sections 401 and 403, there is no culpability 97 requirement that the investment advisor representative knows or in the exercise of reasonable care should have known of a suspension or bar because the order should be received by the investment advisor representative. As with Sections 401 and 403, the administrator may waive this prohibition. Cf. Comment 17 to Section 412. 5. The administrator may adopt rules or orders under Section 404, f, in accordance with Section 605. The Securities and Exchange Commission has adopted a rule that addresses referral fees in Rule 206, 4, 3 of the Investment Advisors Act of 1940. 6. For a state that intends to extend Section 404, f, to those broker-dealers and investment advisors who are not required to register and those federal covered investment advisors not required to file a notice, this subsection should read, f, referral fees. An investment advisor registered under this Act, a federal covered investment advisor that has filed a notice under Section 405, or a broker-dealer registered under this Act is not required to employ or associate with an individual as an investment advisor representative if the only compensation paid to the individual for a referral of investment advisory clients is paid to an investment advisor registered under this Act, or not required to register under this Act, a federal covered investment who has filed a notice under Section 405 or is not required to file a notice under Section 405, or a broker-dealer registered under this Act or not required to register under this Act with which the individual is employed or associated as an investment advisor representative. Section 405. Federal Covered Investment Advisor Notice Filing Requirement. A. Notice filing requirement. Except with respect to a federal covered investment advisor described in subsection B, it is unlawful for a federal covered investment advisor to transact business in the state as a federal covered investment advisor unless the federal covered investment advisor complies with subsection C. B. Notice filing requirement not required. The following federal covered investment advisors are not required to comply with subsection C. 1. A federal covered investment advisor without a place of business in the state if its 98 only clients in the state are A. Federal covered investment advisors registered under this Act, and broker-dealers registered under this Act. B. Institutional investors. C. Bona fide pre-existing clients whose principal places of residence are not in the state, or D. Other clients specified by rule adopted or order issued under this Act. 2. A federal covered investment advisor without a place of business in the state if the person has had, during the preceding 12 months, not more than 5 clients that are resident in the state in addition to those specified under paragraph 1, and 3, any other person excluded by rule adopted or order issued under this Act. C. Notice filing procedure. A person acting as a federal covered investment advisor, not excluded under subsection B, shall file a notice, a consent to service of process complying with Section 611, and such records as have been filed with the Securities and Exchange Commission under the Investment Advisors Act of 1940 required by rule adopted or order issued under this Act and pay the fees specified in Section 410, e. D. Effectiveness of filing. The notice under subsection C becomes effective upon its filing. Official comments. No prior provision. 1. Federal covered investment advisor is defined in Section 102, 6. The scope of the Section 405, a. reference to transacts business in the state is specified in Section 610. 99-2. Section 405, b. 2. is necessitated by the National Securities Markets Improvement Act of 1996 and is intended to coordinate this act with the Investment Advisors Act of 1940. 3. Section 404, c. provides limits on those who can be employed by or associated with a federal covered investment advisor. 4. The succession provision of Section 407, a. is available to a federal covered investment advisor who has filed a notice under Section 405. Section 406. Registration by broker-dealer, agent, investment advisor, and investment advisor representative. A. Application for initial registration. A person shall register as a broker-dealer, agent, investment advisor, or investment advisor representative by filing an application and a consent to service of process complying with Section 611, and paying the fee specified in Section 410 and any reasonable fees charged by the designee of the administrator for processing the filing. The application must contain, 1. The information or record required for the filing of a uniform application, and, 2. Upon request by the administrator, any other financial or other information or record that the administrator determines is appropriate. B. Amendment. If the information or record contained in an application filed under subsection A is or becomes inaccurate or incomplete in a material respect, the registrant shall promptly file a correcting amendment. C. Effectiveness of registration. If an order is not in effect and a proceeding is not pending under Section 412, registration becomes effective at noon on the 45th day after a completed application is filed, unless the registration is denied. A rule adopted or order issued 100 under this Act may set an earlier effective date or may defer the effective date until noon on the 45th day after the filing of any amendment completing the application. D. Registration renewal. A registration is effective until midnight on December 31st of the year for which the application for registration is filed. Unless an order is in effect under Section 412, a registration may be automatically renewed each year by filing such records as are required by rule adopted or order issued under this Act, by paying the fee specified in Section 410, and by paying costs charged by the designee of the administrator for processing the filings. E. Additional conditions or waivers. A rule adopted or order issued under this Act may impose such other conditions, not inconsistent with the National Securities Markets Improvement Act of 1996. An order issued under this Act may waive, in whole or in part, specific requirements in connection with registration as are in the public interest and for the protection of investors. Official comments. Prior provisions, 1956 Act Section 202, RUSA Sections 205, 208. 1. Under Section 406, A. The administrator is authorized to accept standardized forms such as Form BD for broker-dealers, Form U4 for agents and investment advisor representatives, and Form ADV for investment advisors, which are filed today through such designees as the Web CRD or the Investment Advisor Registration Depository, IARD. While this Act generally encourages uniformity, Sections 406, A, and E, are intended to give the administrator authority to augment or waive disclosure requirements in appropriate cases. 2. Section 406, A, eliminates the listing of specified information delineated in Section 202 of the 1956 Act. As with RUSA Section 205, the intent is to facilitate coordination with widely used standardized forms. 3. Under this Act, a single person may act both as an agent and investment advisor representative if the person satisfies applicable registration requirements to be both an agent and investment advisor representative. 101 Section 407. Succession and change in registration of broker-dealer or investment advisor. A. Succession. A broker-dealer or investment advisor may succeed to the current registration of another broker-dealer or investment advisor or a notice filing of a federal covered investment advisor, and a federal covered investment advisor may succeed to the current registration of an investment advisor or notice filing of another federal covered investment advisor, by filing as a successor an application for registration pursuant to Section 401 or 403 or a notice pursuant to Section 405 for the unexpired portion of the current registration or notice filing. B. Organizational change. A broker-dealer or investment advisor that changes its form of organization or state of incorporation or organization may continue its registration by filing an amendment to its registration if the change does not involve a material change in its financial condition or management. The amendment becomes effective when filed or on a date designated by the registrant in its filing. The new organization is a successor to the original registrant for the purposes of this Act. If there is a material change in financial condition or management, the broker-dealer or investment advisor shall file a new application for registration. A predecessor registered under this Act shall stop conducting its securities business other than winding down transactions and shall file for withdrawal of broker-dealer or investment advisor registration within 45 days after filing its amendment to effect succession. C. Name change. A broker-dealer or investment advisor that changes its name may continue its registration by filing an amendment to its registration. The amendment becomes 102 effective when filed or on a date designated by the registrant. D. Change of control. A change of control of a broker-dealer or investment advisor may be made in accordance with a rule adopted or order issued under this Act. Official comments. Prior provisions, 1956 Act Section 202, c. Rusa 210. 1. Section 407 is intended to avoid unnecessary interruptions of business by specifying procedures for a successor broker-dealer or investment advisor, a broker-dealer or investment advisor to maintain its registration if it changes its form of organization or name, or, in accordance with a rule or order adopted under this Act, a change of control of a broker-dealer or investment advisor. 2. There is no filing fee under Section 407. Section 408. Termination of employment or association of agent and investment advisor representative and transfer of employment or association. A. Notice of termination. If an agent registered under this Act terminates employment by or association with a broker-dealer or issuer, or if an investment advisor representative registered under this Act terminates employment by or association with an investment advisor or federal covered investment advisor, or if either registrant terminates activities that require registration as an agent or investment advisor representative, the broker-dealer, issuer, investment advisor, or federal covered investment advisor shall promptly file a notice of termination. If the registrant learns that the broker-dealer, issuer, investment advisor, or federal covered investment advisor has not filed the notice, the registrant may do so. 103. B. Transfer of employment or association. If an agent registered under this Act terminates employment by or association with a broker-dealer registered under this Act and begins employment by or association with another broker-dealer registered under this Act, or if an investment advisor representative registered under this Act terminates employment by or association with an investment advisor registered under this Act or a federal covered investment advisor that has filed a notice under Section 405 and begins employment by or association with another investment advisor registered under this Act or a federal covered investment advisor that has filed a notice under Section 405, then upon the filing by or on behalf of the registrant, within 30 days after the termination, of an application for registration that complies with the requirement of Section 406a, and payment of the filing fee required under Section 410, the registration of the agent or investment advisor representative is, 1. Immediately effective as of the date of the completed filing, if the agent's central registration depository record or successor record or the investment advisor representative's investment advisor registration depository record or successor record does not contain a new or amended disciplinary disclosure within the previous 12 months, or, 2. Temporarily effective as of the date of the completed filing, if the agent's central registration depository record or successor record or the investment advisor representative's investment advisor registration depository record or successor record contains a new or amended disciplinary disclosure within the preceding 12 months. C. Withdrawal of temporary registration. The administrator may withdraw a temporary registration if there are or were grounds for discipline as specified in Section 412 and the administrator does so within 30 days after the filing of the application. If the administrator 104 does not withdraw the temporary registration within the 30-day period, registration becomes automatically effective on the 31st day after filing. D. Power to prevent temporary registration. The administrator may prevent the effectiveness of a transfer of an agent or investment advisor representative under subsection B. 1, or 2, based on the public interest and the protection of investors. E. Termination of registration or application for registration. If the administrator determines that a registrant or applicant for registration is no longer in existence or has ceased to act as a broker-dealer, agent, investment advisor, or investment advisor representative, or is the subject of an adjudication of incapacity or is subject to the control of a committee, conservator, or guardian, or cannot reasonably be located, a rule adopted or order issued under this Act may require the registration be cancelled or terminated or the application denied. The administrator may reinstate a cancelled or terminated registration, with or without hearing, and may make the registration retroactive. Official comments. Prior provision, 1956 Act Section 204, d. 1 under Sections 402, c, and 404, c, registration of an agent or investment advisor representative is effective only while the agent or investment advisor representative is employed by or associated with a broker-dealer, issuer, or investment advisor, as may be the case. Section 408, a, specifies a procedure to inform the administrator of a notice of termination. 2. To expedite transfer to a new broker-dealer or investment advisor, Section 408, b, provides a procedure by which agents or investment advisor representative registration will be effective immediately as of the date of new employment when there is no new or added disciplinary disclosure in the relevant central research depository or investment advisor registration depository records. Both electronic systems are currently administered by the National Association of Securities Dealers. Section 408, d, is intended to ensure that the administrator has the authority to prevent immediate effectiveness in appropriate cases. 105 Section 409. Withdrawal of registration of broker-dealer, agent, investment advisor, and investment advisor representative. Withdrawal of registration by a broker-dealer, agent, investment advisor, or investment advisor representative becomes effective 60 days after the filing of the application to withdraw or within any shorter period as provided by rule adopted or order issued under this Act unless a revocation or suspension proceeding is pending when the application is filed. If a proceeding is pending, withdrawal becomes effective when and upon such conditions as required by rule adopted or order issued under this Act. The administrator may institute a revocation or suspension proceeding under Section 412 within 1 year after the withdrawal became effective automatically and issue a revocation or suspension order as of the last date on which registration was effective if a proceeding is not pending. Official comments. Prior provisions, 1956 Act Section 204, e, RUSA Section 214(1). This section generally follows the 1956 Act Section 204, e, and RUSA Section 214. This section does not affect any applicant's privilege of withdrawal of an application from registration before the registration becomes effective. It is simply designed to prevent withdrawal of an effective registration under fire. The last sentence preserves the ability of the administrator to initiate an action under Section 412 when the administrator does not know of a reason to object to withdrawal until after withdrawal has become effective. 2. Ordinarily today a registrant will file a standardized form such as Form U5, VDW or ADVW to withdraw registration. Section 410. Filing fees. A. Broker-dealers. A person shall pay a fee of $_ when initially filing an 106 application for registration as a broker-dealer and a fee of $_ when filing a renewal of registration as a broker-dealer. If the filing results in a denial or withdrawal, the administrator shall retain $_ of the fee. B. Agents. The fee for an individual is $_ when filing an application for registration as an agent, a fee of $_ when filing a renewal of registration as an agent, and a fee of $_ when filing for a change of registration as an agent. If the filing results in a denial or withdrawal, the administrator shall retain $_ of the fee. C. Investment advisors. A person shall pay a fee of $___ when filing an application for registration as an investment advisor and a fee of $___ when filing a renewal of registration as an investment advisor. If the filing results in a denial or withdrawal, the administrator shall retain $___ of the fee. D. Investment advisor representatives. The fee for an individual is $___ when filing an application for registration as an investment advisor representative, a fee of $___ when filing a renewal of registration as an investment advisor representative, and a fee of $___ when filing a change of registration as an investment advisor representative. If the filing results in a denial or withdrawal, the administrator shall retain $___ of the fee. E. Federal Covered Investment Advisors. A federal covered investment advisor required to file a notice under Section 405 shall pay an initial fee of $___ and an annual notice fee of $___. F. Payment. A person required to pay a filing or notice fee under this section may transmit the fee through or to a designee as a rule or order provides under this Act. G. Dual agent/investment advisor representative. An investment advisor 107 representative who is registered as an agent under Section 402 and who represents a person that is both registered as a broker-dealer under Section 401 and registered as an investment advisor under Section 403 or required as a federal covered investment advisor to make a notice filing under Section 405 is not required to pay an initial or annual registration fee for registration as an investment advisor representative. Official comments. Prior provisions, 1956 Act Section 202, b. RUSA Section 206. 1. Each state should determine the appropriate fee for each type of registration and for each type of renewal, denial, or withdrawal of a registration. 2. Similarly, each state should determine whether it wishes to remove the brackets from Section 410, g, and charge a single fee for duly registered agents and investment advisor representatives. 3. If a state prefers to have the fees in this section established by rule, amend this section to read as follows, inserting the appropriate reference to the State's Administrative Procedure Act, Section 410. Filing fees. A. Fee established by administrator. The administrator shall establish fees by rule pursuant to the State Administrative Procedure Act for 1. An initial filing of an application as a broker-dealer and renewal of an application by a broker-dealer for registration, but, if the filing results in a denial or withdrawal, the administrator shall retain an amount of the fee established by the administrator. 2. An application for registration as an agent and renewal of registration as an agent, but, if the filing results in a denial or withdrawal, the administrator shall retain an amount of the fee established by the administrator. 3. An application for registration as an investment advisor and renewal of registration as an investment advisor, but, if the filing results in a denial or withdrawal, the administrator shall retain an amount of the fee established by the administrator. 4. An application for registration as an investment advisor representative, a renewal of registration as an investment advisor representative, and a change of registration as an investment advisor representative, but, if the filing results in a denial or withdrawal, the administrator shall retain an amount of the fee established by the administrator, and 5. An initial fee and annual notice fee for a federal covered investment advisor 108 required to file a notice under Section 405. B. Payment. A person required to pay a filing or notice fee under this section may transmit the fee through or to a designee as a rule or order provides under this Act. C. Dual agent/investment advisor representative. An investment advisor representative who is registered as an agent under Section 402 and who represents a person that is both registered as a broker-dealer under Section 401 and registered as an investment advisor under Section 403 or required as a federal covered investment advisor to make a notice filing under Section 405 is not required to pay an initial or annual registration fee for registration as an investment advisor representative. Section 411. Post-registration requirements. A. Financial requirements. Subject to Section 15, H, of the Securities Exchange Act of 1934, 15 U.S.C. Section 780, H, or Section 222 of the Investment Advisors Act of 1940, 15 U.S.C. Section 80b 22, a rule adopted or order issued under this Act may establish minimum financial requirements for broker-dealers registered or required to be registered under this Act and investment advisors registered or required to be registered under this Act. B. Financial reports. Subject to Section 15, H, of the Securities Exchange Act of 1934, 15 U.S.C. Section 780, H, or Section 222, B, of the Investment Advisors Act of 1940, 15 U.S.C. Section 80b 22, a broker-dealer registered or required to be registered under this Act and an investment advisor registered or required to be registered under this Act shall file such financial reports as are required by a rule adopted or order issued under this Act. If the information contained in a record filed under this subsection is or becomes inaccurate or incomplete in a material respect, the registrant shall promptly file a correcting amendment. C. Record keeping. Subject to Section 15, H, of the Securities Exchange Act of 1934, 15 U.S.C. Section 780, H, or Section 222 of the Investment Advisors Act of 1940, 15 U.S.C. Section 80b 22 109, 1. A broker-dealer registered or required to be registered under this Act and an investment advisor registered or required to be registered under this Act shall make and maintain the accounts, correspondence, memoranda, papers, books, and other records required by rule adopted or order issued under this Act. 2. Broker-dealer records required to be maintained under paragraph 1, may be maintained in any form of data storage acceptable under Section 17, A, of the Securities Exchange Act of 1934, 15 U.S.C. Section 78q, A, if they are readily accessible to the administrator, and 3. Investment advisor records required to be maintained under paragraph 1, may be maintained in any form of data storage required by rule adopted or order issued under this Act. D. Audits or inspections. The records of a broker-dealer registered or required to be registered under this Act and of an investment advisor registered or required to be registered under this Act are subject to such reasonable periodic, special, or other audits or inspections by a representative of the administrator, within or without the state, as the administrator considers necessary or appropriate in the public interest and for the protection of investors. An audit or inspection may be made at any time and without prior notice. The administrator may copy, and remove for audit or inspection copies of, all records the administrator reasonably considers necessary or appropriate to conduct the audit or inspection. The administrator may assess a reasonable charge for conducting an audit or inspection under this subsection. E. Custody and discretionary authority bond or insurance. Subject to Section 15, H, of the Securities Exchange Act of 1934, 15 U.S.C. Section 780, H, or Section 222 of the Investment Advisors Act of 1940, 15 U.S.C. Section 80b 22, a rule adopted or order issued under this Act may require a broker-dealer or investment advisor that has custody of or 110 discretionary authority over funds or securities of a customer or client to obtain insurance or post a bond or other satisfactory form of security in an amount not to exceed $___. The administrator may determine the requirements of the insurance, bond, or other satisfactory form of security. Insurance or a bond or other satisfactory form of security may not be required of a broker-dealer registered under this Act whose net capital exceeds, or of an investment advisor registered under this Act whose minimum financial requirements exceed, the amounts required by rule or order under this Act. The insurance, bond, or other satisfactory form of security must permit an action by a person to enforce any liability on the insurance, bond, or other satisfactory form of security if instituted within the time limitations in Section 509, J, 2. F. Requirements for custody. Subject to Section 15, H, of the Securities Exchange Act of 1934, 15 U.S.C. Section 78O, H, or Section 222 of the Investment Advisors Act of 1940, 15 U.S.C. Section 80B 22, an agent may not have custody of funds or securities of a customer except under the supervision of a broker-dealer, and an investment advisor representative may not have custody of funds or securities of a client except under the supervision of an investment advisor or a federal covered investment advisor. A rule adopted or order issued under this act may prohibit, limit, or impose conditions on a broker-dealer regarding custody of funds or securities of a customer and on an investment advisor regarding custody of securities or funds of a client. G. Investment Advisor Brochure Rule. With respect to an investment advisor registered or required to be registered under this Act, a rule adopted or order issued under this Act may require that information or other record be furnished or disseminated to clients or prospective clients in the state as necessary or appropriate in the public interest and for the 111 protection of investors and advisory clients. H. Continuing education. A rule adopted or order issued under this Act may require an individual registered under Section 402 or 404 to participate in a continuing education program approved by the Securities and Exchange Commission and administered by a self-regulatory organization, or, in the absence of such a program, a rule adopted or order issued under this Act may require continuing education for an individual registered under Section 404. Official comments. Prior provisions, 1956 Act Sections 102, C, 202, D, and E, and 203, RUSA Sections 209, 211 and 215. 1 Sections 411, A, through, C, and E, through, F, implicitly refer to capital, custody, margin, financial responsibility, making and keeping records, bonding, or financial or operational reporting requirements. Under the National Securities Markets Improvement Act of 1996, states may not impose such requirements on covered broker-dealers and investment advisors greater than those specified in Section 15, H, of the Securities Exchange Act of 1934 and Section 222 of the Investment Advisors Act of 1940. 2 Minimum financial requirements must be maintained during the entire time a person is registered and not merely at the time of the registration. C. E.g., National Grange Mud. INS Kobe Priolo, 236 S.E.2 D 808, SC 1977, Continuing Bond Requirement, Ridgway, McLeod, and Association, 281 A.2 D 390, NJ Super. CTFDIB 1971, Continuing Minimum Capital Requirement. 3. The duty in Section 411, B, to correct or update information is limited to material information which a reasonable investor would continue to consider important in deciding whether to purchase or sell securities. CFTSC Industry, Inc. v. Northway, Inc., 426 U.S. 438, 444,450, 1970, Securities Act Release No. 6084, 17 SEC Doc. 1048, 1054, 1979, persons are continuing to rely on all or any material portion of the statements. 4. Section 411, C, 1, authorizes the administrator to require all records to be preserved for the period the administrator prescribes by rule or order. 5. Rule 17A4 is the current rule under Section 17A of the Securities Exchange Act referred to in Section 411, C, 2, that addresses acceptable forms of data storage. 112.6. The administrator's power to copy and examine records in Section 411, D, is subject to all applicable privileges. C, e.g., 10 Lewis Loss and Joel Seligman, Securities Regulation 492149259.69, 3D Ed Rev 1996. The power in Section 411, d, to conduct audits or inspections is distinguishable from the administrator's enforcement powers under Section 602. No subpoena is necessary under Section 411, d. Failure to submit to a reasonable audit or inspection is a violation of this Act, which may result in an action by the administrator under Section 412, d. 8, a criminal prosecution under Section 508, or an injunction under Section 603. An unreasonable audit, inspection, or demand for information or documents would be subject to challenge in an appropriate court. 7. Section 411, f, broadens 1956 Act Section 102, c, and RUSA Section 215 to apply to agents as well as investment advisor representatives. Subject to Section 15, h, of the Securities Exchange Act of 1934 and Section 222 of the Investment Advisor Act of 1940, the administrator is given broad authority to prohibit, limit, or condition custody arrangements. 8. Section 411, g, parallels Rule 204-3, adopted under the Investment Advisors Act of 1940, popularly known as the Brochure Rule, which authorizes the SEC to require dissemination to investment advisor clients of specified information about the investment advisor and investment advice. Section 412. Denial, revocation, suspension, withdrawal, restriction, condition, or limitation of registration. A. Disciplinary conditions applicants. If the administrator finds that the order is in the public interest and subsection d. authorizes the action, an order issued under this Act may deny an application, or may condition or limit registration, 1. of an applicant to be a broker-dealer, agent, investment advisor, or investment advisor representative, and 2. if the applicant is a broker-dealer or investment advisor, of any partner, officer, director, person having a similar status or performing similar functions, or person directly or indirectly controlling the broker-dealer or investment advisor. B. Disciplinary conditions, registrants. If the administrator finds that the order is in 113 the public interest and subsection d. authorizes the action, an order issued under this Act may revoke, suspend, condition, or limit the registration of a registrant, and if the registrant is a broker-dealer or investment advisor, any partner, officer, or director, any person having a similar status or performing similar functions, or any person directly or indirectly controlling the broker-dealer or investment advisor. However, the administrator, 1. may not institute a revocation or suspension proceeding under this subsection based on an order issued by another state that is reported to the administrator or designee later than 1 year after the date of the order on which it is based, and 2. under subsection d. 5. A, and b. may not issue an order on the basis of an order under the State Securities Act of another state unless the other order was based on conduct for which subsection d. would authorize the action had the conduct occurred in the state. C. Disciplinary penalties, registrants. If the administrator finds that the order is in the public interest and subsection d. 1 through 6, 8, 9, 10, or 12, and 13, authorizes the action, an order under this Act may censure, impose a bar, or impose a civil penalty in an amount not to exceed a maximum of $___ for a single violation or $___ for several violations on a registrant, and if the registrant is a broker-dealer or investment advisor, any partner, officer, or director, any person having similar functions, or any person directly or indirectly controlling the broker-dealer or investment advisor. D. Grounds for discipline. A person may be disciplined under subsections A through C if the person, 1. has filed an application for registration in the state under this Act or the predecessor Act within the previous 10 years, which, as of the effective date of registration or as 114 of any date after filing in the case of an order denying effectiveness, was incomplete in any material respect or contained a statement that, in light of the circumstances under which it was made, was false or misleading with respect to a material fact. 2. Willfully violated or willfully failed to comply with this act or the predecessor act or a rule adopted or order issued under this act or the predecessor act within the previous 10 years. 3. Has been convicted of a felony or within the previous 10 years has been convicted of a misdemeanor involving a security, a commodity future or option contract, or an aspect of a business involving securities, commodities, investments, franchises, insurance, banking, or finance. 4. Is enjoined or restrained by a court of competent jurisdiction in an action instituted by the administrator under this act or the predecessor act, a state, the Securities and Exchange Commission, or the United States from engaging in or continuing an act, practice, or course of business involving an aspect of a business involving securities, commodities, investments, franchises, insurance, banking, or finance. 5. Is the subject of an order, issued after notice and opportunity for hearing by a. the securities, depository institution, insurance, or other financial services regulator of a state or by the Securities and Exchange Commission or other federal agency denying, revoking, barring, or suspending registration as a broker-dealer, agent, investment advisor, federal covered investment advisor, or investment advisor representative. B. The securities regulator of a state or by the Securities and Exchange Commission against a broker-dealer, agent, investment advisor. Investment advisor 115 representative, or federal covered investment advisor. C. The Securities and Exchange Commission or by a self-regulatory organization suspending or expelling the registrant from membership in the self-regulatory organization. D. A court adjudicating a United States Postal Service fraud order. E. The insurance regulator of a state denying, suspending, or revoking the registration of an insurance agent, or F. A depository institution regulator suspending or barring a person from the depository institution business. 6. Is the subject of an adjudication or determination, after notice and opportunity for hearing, by the Securities and Exchange Commission, the Commodity Futures Trading Commission, the Federal Trade Commission, a federal depository institution regulator, or a depository institution, insurance, or other financial services regulator of a state that the person willfully violated the Securities Act of 1933, the Securities Exchange Act of 1934, the Investment Advisors Act of 1940, the Investment Company Act of 1940, or the Commodity Exchange Act, the Securities or Commodities Law of a state, or a federal or state law under which a business involving investments, franchises, insurance, banking, or finance is regulated. 7. Is insolvent, either because the person's liabilities exceed the person's assets or because the person cannot meet the person's obligations as they mature, but the administrator may not enter an order against an applicant or registrant under this paragraph without a finding of insolvency as to the applicant or registrant. 8. Refuses to allow or otherwise impedes the administrator from conducting an audit or inspection under Section 411, d, or refuses access to a registrant's office to conduct an audit or 116 inspection under Section 411, d. 9. Has failed to reasonably supervise an agent, investment advisor representative, or other individual, if the agent, investment advisor representative, or other individual was subject to the person's supervision and committed a violation of this act or the predecessor act or a rule adopted or order issued under this act or the predecessor act within the previous 10 years. 10. Has not paid the proper filing fee within 30 days after having been notified by the administrator of a deficiency, but the administrator shall vacate an order under this paragraph when the deficiency is corrected. 11. After notice and opportunity for a hearing, has been found within the previous 10 years, a. by a court of competent jurisdiction to have willfully violated the laws of a foreign jurisdiction under which the business of securities, commodities, investment, franchises, insurance, banking, or finance is regulated. B. to have been the subject of an order of a securities regulator of a foreign jurisdiction denying, revoking, or suspending the right to engage in the business of securities as a broker-dealer, agent, investment advisor, investment advisor representative, or similar person, or, c. to have been suspended or expelled from membership by or participation in a securities exchange or securities association operating under the securities laws of a foreign jurisdiction. 12. Is the subject of a cease and desist order issued by the Securities and Exchange Commission or issued under the securities, commodities, investment, franchise, banking, finance, or insurance laws of a state. 117. 13. Has engaged in dishonest or unethical practices in the securities, commodities, investment, franchise, banking, finance, or insurance business within the previous 10 years, or, 14, is not qualified on the basis of factors such as training, experience, and knowledge of the securities business. However, in the case of an application by an agent for a broker-dealer that is a member of a self-regulatory organization or by an individual for registration as an investment advisor representative, a denial order may not be based on this paragraph if the individual has successfully completed all examinations required by subsection E. The administrator may require an applicant for registration under section 402 or 404 who has not been registered in a state within the 2 years preceding the filing of an application in the state to successfully complete an examination. E. Examinations. A rule adopted or order issued under this Act may require that an examination, including an examination developed or approved by an organization of securities regulators, be successfully completed by a class of individuals or all individuals. An order issued under this Act may waive, in whole or in part, an examination as to an individual, and a rule adopted under this Act may waive, in whole or in part, an examination as to a class of individuals if the administrator determines that the examination is not necessary or appropriate in the public interest and for the protection of investors. F. Summary process. The administrator may suspend or deny an application summarily, restrict, condition, limit, or suspend a registration, or censure, bar, or impose a civil penalty on a registrant before final determination of an administrative proceeding. Upon the issuance of an order, the administrator shall promptly notify each person subject to the order that the order has been issued, the reasons for the action, and that within 15 days after the receipt of a 118 request in a record from the person the matter will be scheduled for a hearing. If a hearing is not requested and none is ordered by the administrator within 30 days after the date of service of the order becomes final by operation of law. If a hearing is requested or ordered, the administrator, after notice of an opportunity for hearing to each person subject to the order, may modify or vacate the order or extend the order until final determination. G. Procedural requirements. An order issued may not be issued under this section, except under subsection F, without 1. Appropriate notice to the applicant or registrant, 2. Opportunity for hearing, and 3. Findings of fact and conclusions of law in a record in accordance with the State Administrative Procedure Act. H. Control person liability. A person that controls, directly or indirectly, a person not in compliance with this section may be disciplined by order of the administrator under subsections A through C, to the same extent as the non-complying person, unless the controlling person did not know, and in the exercise of reasonable care could not have known, of the existence of conduct that is a ground for discipline under this section. I. Limit on investigation or proceeding. The administrator may not institute a proceeding under subsection A, B, or C, based solely on material facts actually known by the administrator unless an investigation or the proceeding is instituted within 1 year after the administrator actually acquires knowledge of the material facts. Official comments. Prior provisions, 1956 Act Section 204, RUSA Sections 207, 212 to 213. 119.1. Section 412 generally follows Section 204 of the 1956 Act and Sections 207 and 212,213 of RUSA, but has been modified to reflect subsequent developments that have broadened the scope and remedies of counterpart federal and state statutes. 2. Section 412 authorizes the administrator to seek a sanction based on the seriousness of the misconduct. Under Section 412, the administrator must prove that the denial, revocation, suspension, cancellation, withdrawal, restriction, condition, or limitation both is, 1. in the public interest and, 2. involves one of the enumerated grounds in Section 412, d. c. e.g., Mayflower Secretary Co., Inc. v. Bureau of Seconds, 312A.2 d. 497, NJ 1973. The public interest is a much litigated concept that has come to have settled meanings. See generally 6L Loss and J. Seligman, Securities Regulation 3103.5 to 3103.18, 3D ed. Rev. 2002, under federal securities laws. The public interest will not require imposition of a sanction for every minor or technical violation of subsection d. 3. The term foreign means a jurisdiction outside of the United States, not a different state within the United States. 4. Section 412, a. through c. authorizes the administrator to proceed against an entire firm, regardless of whether the administrator proceeds against any individual, when an individual partner, officer, or director or person occupying a similar status or performing similar functions, or a controlling person is disciplined under subsection d, but only if proceeding against the entire firm is in the public interest. The discipline of such an individual may not automatically be used against a broker-dealer or investment advisor. When, however, there is a failure to reasonably supervise, see Section 412, d. 9, or control person liability, see Section 412, h, the administrator is empowered to proceed against a firm in an appropriate case. In Section 412, any partner, officer, or director, any person occupying a similar status or performing similar function can include a branch manager, assistant branch manager, or other supervisor. 5. In Section 412, d. 1, the completeness and accuracy of an effective application for registration is tested as of the appropriate effective date. An application that becomes incomplete or inaccurate after its effective date is not a ground for discipline under paragraph d. 1. In an appropriate case, an action might be available under paragraph d. 2, and Section 406, b. On the other hand, in a proceeding to deny effectiveness to a pending application for registration, the completeness and accuracy of the application is not limited to the effective date and can be judged on any date after filing. 6. The term willfully in Section 412, d. 2, and 11, a, is discussed in Comment 2 to Section 508. 7. There is no time limit or statute of limitations on felony convictions in Section 412, d. 3, as a ground for disciplinary action. 128. The present tense of the verb is in Sections 412, d. 4, through 6, and 12, means that an injunction, order, adjudication, or determination that has expired or been vacated is no longer a ground for discipline. 9. In Sections 412, d. 5, and 6, the administrator is not required to prove the validity of the ground which led to the earlier disciplinary order. 10. Under Section 412, d. 7, the administrator may not proceed against a broker-dealer or investment advisor firm on the basis of the insolvency of a partner, officer, director, controlling person, or other person specified in subsection b, unless it is a sole proprietorship. 11. Section 412, d. 8, can be violated by a refusal to cooperate with an administrator's reasonable audit or inspection, including by withholding or concealing records, refusing to furnish required records, or refusing the administrator reasonable access to any office or location within an office to conduct an audit or inspection under this Act. However, a request by a person subject to an audit or inspection for a reasonable delay to obtain assistance of counsel does not constitute a violation of Section 412, d. 8. 12. The term failed to supervise reasonably in Section 412, d. 9, includes not having reasonable supervisory procedures in place as well as a proper system of supervision and internal control. Cf. Hollinger v. Titan Capital Corp., 914 F.2 D 1564, 9th Sir 1990, Cert. Denied, 499 U.S. 976, 1991. Section 15, B, 4, E, of the Securities Exchange Act of 1934 similarly addresses failure to supervise reasonably. C6 Lewis Loss and Joel Seligman, Securities Regulation 3097-3101, 3D ed. Rev. 2002. 13. The term dishonest and unethical practices in Section 412, d. 13, has been held not to be unconstitutionally vague. C. E.g., Brewster v. Maryland Secretary COMMN, 548A.2 D 157, 160, MDCT Spec App 1988, a broad statutory standard is not vague if it has a meaningful referent in business practice, custom, or usage. Johnson Bowles Co. v. Division of Seconds, 829p.2 D 101, 114, Utah CT App 1992. Such legislative language bespeaks a legislative intent to delegate the interpretation of what constitutes dishonest and unethical practices in the securities industry to the administrator. Ministerial or clerical violations of a statute or rule, if immaterial and occurring without intent or recklessness, typically would not constitute dishonest or unethical practices. 14. Under the counterparts to Section 412, d. 14, and e. applicants to become agents of broker-dealers typically take standardized tests administered by the National Association of Securities Dealers, Inc. 15. Sections 412, f, and g, amplify the earlier procedures found in Section 204, f, of the 1956 Act and are intended to facilitate summary disciplinary proceedings, when these are appropriate. 121-16. Section 412, I, parallels the language of Section 204 of the 1956 Act and Section 212, b, of RUSA with some significant changes. The time period in which the administrator can act has been extended to 1 year from 30 days in the 1956 Act and 90 days in RUSA. The limitation on instituting a proceeding can also be told by instituting a formal investigation. The addition of the word solely is intended to make it clear that an administrator may consider the prior history of an applicant or registrant even if that prior history had been known to the administrator for more than 1 year if there are additional material facts which are actually known to the administrator within the last year. 17. Actually known in Section 412, I, is used to signify that the mere filing of material facts in the Central Registration Depository or Investment Advisory Registration Depository systems does not constitute actual knowledge, unless that information was received by the administrator, or, but for a decision by the administrator, would have been received by the administrator. 122 Article 5 Fraud and Liabilities Section 501. General fraud. It is unlawful for a person, in connection with the offer, sale, or purchase of a security, directly or indirectly, 1. To employ a device, scheme, or artifice to defraud, 2. To make an untrue statement of a material fact or to omit to state a material fact necessary in order to make the statement made, in the light of the circumstances under which it is made, not misleading, or, 3. To engage in an act, practice, or course of business that operates or would operate as a fraud or deceit upon another person. Official comments. Prior provisions, 1956 Act Section 101, RUSA Section 501. 1. Section 501, which was Section 101 in the 1956 Act, was modeled on Rule 10b-5 adopted under the Securities Exchange Act of 1934 and on Section 17(a) of the Securities Act of 1933. There has been significant later case development interpreting Rule 10b-5, Section 17(a), and Section 101 of the 1956 Act. Section 501 is not identical to either Rule 10b-5 or Section 17(a). 2. There are no exemptions from Section 501. 3. Section 501 applies to any securities offer, sale, or purchase, including offers, sales, or purchases involving registered, exempt, or federal covered securities. It would also apply to a rescission offer under Section 510. 4. The possible consequences of violating Section 501 are many. These include denial, suspension, or revocation of securities registration under Section 306, denial, revocation, suspension, withdrawal, restriction, condition, or limitation of a broker-dealer, agent, investment advisor, or investment advisor representative registration under Section 412, criminal prosecution 123 under Section 508, civil enforcement proceedings under Section 603, and administrative proceedings under 604. 5. Because Section 501, like Rule 10b-5, reaches market manipulation, see 8 Lewis Loss and Joel Seligman, Securities Regulation ch 10.d, 3d ed. 1991, this Act does not include the RUSA market manipulation Section 502, which had no counterpart in the 1956 Act. 6. The culpability required to be pled or proved under Section 501 is addressed in the relevant enforcement context. See, e.g., Section 508, Criminal Penalties, where willfulness must be proven, Section 509, Civil Liabilities, which includes a reasonable care defense, or civil and administrative enforcement actions under Sections 603 and 604, where no culpability is required to be pled or proven. 7. There is no private cause of action, express or implied, under Section 501. Section 509, m, expressly provides that only Section 509 provides a private cause of action for conduct that could violate Section 501. Section 502. Prohibited conduct in providing investment advice. A. Fraud in providing investment advice. It is unlawful for a person that advises others for compensation, either directly or indirectly or through publications or writings, as to the value of securities or the advisability of investing in, purchasing, or selling securities, or that, for compensation and as part of a regular business, issues or promulgates analyses or reports relating to securities. 1. To employ a device, scheme, or artifice to defraud another person, or 2. To engage in an act, practice, or course of business that operates or would operate as a fraud or deceit upon another person. B. Rules defining fraud. A rule adopted under this Act may define an act, practice, or course of business of an investment advisor or an investment advisor representative, other than 124 a supervised person of a federal covered investment advisor, as fraudulent, deceptive, or manipulative, and prescribe means reasonably designed to prevent investment advisors and investment advisor representatives, other than supervised persons of a federal covered investment advisor, from engaging in acts, practices, and courses of business defined as fraudulent, deceptive, or manipulative. C. Rules specifying contents of advisory contract. A rule adopted under this Act may specify the contents of an investment advisory contract entered into, extended, or renewed by an investment advisor. Official comments. Prior provisions, 1956 Act Section 102, A, RUSA Section 503. 1. Section 502, A, applies to any person that commits fraud in providing investment advice. Section 502, B, is not limited to persons registered as investment advisors or investment advisor representatives. 2. A person can violate both Section 501 and Section 502 if the person violates Section 502 in connection with the offer, purchase, or sale of a security. 3. The rulemaking authority under Sections 502, B, and C, would provide the basis for existing NASAA rules concerning investment advisors, to the extent these rules are not preempted by the National Securities Markets Improvement Act of 1996. 4. Under Section 203A, B, 2, of the Investment Advisors Act, states retain their authority to investigate and bring enforcement actions with respect to fraud or deceit against a federal covered investment advisor or a person associated with a federal covered investment advisor. Under Section 502A, which applies to any person, a state could bring an enforcement action against a federal covered investment advisor, including a federal covered investment advisor excluded from the definition of investment advisor in Section 102(15)(e). 5. There is no private cause of action, express or implied, under Section 502. Section 509(m) expressly provides that only Section 509 provides for a private cause of action for prohibited conduct in providing investment advice that could violate Section 502. 125. Section 503. Evidentiary burden. A. Civil. In a civil action or administrative proceeding under this Act, a person claiming an exemption, exception, preemption, or exclusion has the burden to prove the applicability of the claim. B. Criminal. In a criminal proceeding under this Act, a person claiming an exemption, exception, preemption, or exclusion has the burden of going forward with evidence of the claim. Official comment. Prior provisions, 1956 Act Section 402, D, RUSA Section 608. 1. As specified in Section 503, A, in a civil or administrative action, the person claiming an exemption, exception, preemption, or exclusion has the burden of persuasion. 2. In contrast, in a criminal action under Section 503, B, the prosecutor is required to prove each element of a crime beyond a reasonable doubt. The defendant only has the burden of producing evidence of an exemption, exception, preemption, or exclusion. Some court decisions have characterized this burden as an affirmative defense. See, e.g., United States ex rel. Schott v. Tayan, 365 F.2 D 191, 195, 6th Sir 1966, Ohio Blue Sky Law constitutionally shifts burden of production to defendant, Commonwealth v. David, 309 N.E.2 D 484, 488, Massachusetts 1974, exemption is an affirmative defense, State v. Frost, 387 N.E.2 D 235, 238 to 239, Ohio 1979, it is not unconstitutional to require the burden of proof as an affirmative defense to prove a securities law exemption, State v. Anderson, 773 A.2 D 328, Con 2001, an exemption from registration is an affirmative defense to the charge of selling unregistered securities. Section 504. Filing of sales and advertising literature. A. Filing requirement. Except as otherwise provided in subsection B, a rule adopted or order issued under this Act may require the filing of a prospectus, pamphlet, circular, form letter, advertisement, sales literature, or other advertising record relating to a security or 126 investment advice, addressed or intended for distribution to prospective investors, including clients or prospective clients of a person registered or required to be registered as an investment advisor under this Act. B. Excluded communications. This section does not apply to sales and advertising literature specified in subsection A, which relates to a federal covered security, a federal covered investment advisor, or a security or transaction exempted by Section 201, 202, or 203 except as required pursuant to Section 201, 7. Official comments prior provisions, 1956 Act Section 403, RUSA Section 405. 1. The prospectuses, pamphlets, circulars, form letters, advertisements, sales literature, or advertising communications, include material disseminated electronically or available on a website. 2. The administrator may bring a civil enforcement action in a court under Section 603 or institute administrative enforcement under Section 604 to prevent publication, circulation, or use of any materials required by the administrator to be filed under Section 504 that have not been filed. 3. Section 504(b) is meant to refer to the communications described in Section 504(a). Section 505. Misleading filings. It is unlawful for a person to make or cause to be made, in a record that is used in an action or proceeding or filed under this Act, a statement that, at the time and in the light of the circumstances under which it is made, is false or misleading in a material respect, or, in connection with the statement, to omit to state a material fact necessary to make the statement made, in the light of the circumstances under which it was made, not false or misleading. 127 Official comment prior provisions, 1956 Act Section 404, RUSA Section 504. The definition of materiality in TSC Industry, Inc. v. Northway, Inc., 426 U.S. 438, 449, 1976. An omitted fact is material if there is a substantial likelihood that a reasonable shareholder would consider it important in deciding how to vote, has generally been followed in both federal and state securities law. See for Lewis Loss and Joel Seligman, Securities Regulation 2071-2105, 3D ed. Rev 2000. Section 506. Misrepresentations concerning registration or exemption. The filing of an application for registration, a registration statement, a notice filing under this Act, the registration of a person, the notice filing by a person, or the registration of a security under this Act does not constitute a finding by the administrator that a record filed under this Act is true, complete, and not misleading. The filing or registration or the availability of an exemption, exception, preemption, or exclusion for a security or a transaction does not mean that the administrator has passed upon the merits or qualifications of, or recommended or given approval to, a person, security, or transaction. It is unlawful to make, or cause to be made, to a purchaser, customer, client, or prospective customer or client a representation inconsistent with this section. Official comment prior provisions, 1956 Act Section 405, RUSA Section 505. This section follows the 1956 Act and RUSA, as well as state securities statutes generally, in providing that a misrepresentation concerning registration or an exemption is unlawful. 128 Section 507. Qualified immunity. A broker-dealer, agent, investment advisor, federal covered investment advisor, or investment advisor representative is not liable to another broker-dealer, agent, investment advisor, federal covered investment advisor, or investment advisor representative for defamation relating to a statement that is contained in a record required by the administrator, or designee of the administrator, the Securities and Exchange Commission, or a self-regulatory organization, unless the person knew, or should have known at the time that the statement was made, that it was false in a material respect or the person acted in reckless disregard of the statement's truth or falsity. Official comments. Source of law, National Association of Securities Dealers, Incorporated. Proposal relating to qualified immunity in arbitration proceedings for statements made in Forms U4 and U5. 1. In 1994 the Securities and Exchange Commission Division of Market Regulation published the Large Firm Project, a review of hiring, retention, and supervisory practices, 1994, which found that a small number of rogue brokers were responsible for a significant proportion of customer disciplinary complaints. These brokers in some instances moved from one broker-dealer firm to another, it was explained, without full and complete disclosure of disciplinary problems by the broker-dealer, because of broker-dealer firms' fear of state law defamation claims. See also GAO, actions needed to better protect investors against unscrupulous brokers. 3, 1994, testimony of SEC Chairman Arthur Levitt concerning the large firm project, Subcom. On telecommunications and Fin, How COMM on Energy and Commerce, September 14, 1994, reprinted in 1994 to 1995 Federal Secretary L. Republic, CCH, 85,433, 1994. 2 in 1998, the National Association of Securities Dealers proposed qualified immunity for statements made in Forms U4 and U5 to address this problem. This proposal was reprinted in Securities Exchange Act Release 39892, 66 SEC Doc. 2473, 1998. This proposal was limited to arbitration proceedings. It was not acted on by the Securities and Exchange Commission. 3. An alternative approach would be a standard providing for absolute immunity. See generally and right, Form U5 Defamation, 52 Wash. And Lee L. Revelation 1299, 1995, Achardo v. Millennium Secretary Corp., 83 F sub 2D 413, SDNY 2000, discussing both New York qualified and absolute immunity cases. 129-4. Securities administrators or self-regulatory organizations generally are subject to absolute or qualified immunity for actions of their employees within the course of their official duties. C. 10 Lewis Loss and Joel Seligman, Securities Regulation 4818-4821, 3D ed. Rev. 1996. 5. As is generally the law, truth is a complete defense to a defamation action. Andrews v. Prudential Seconds, Inc., 160 F.3d 304, 308, 6th Sir 1998. 6. An agent who has been the subject of a Form U5, Uniform Termination Notice for Securities Industry Registration, may respond to specified adverse disclosures and have her or his responses reprinted on the published version of Form U5. 7. Through September 2002 no state had adopted an immunity provision in its securities statute. No state has rejected immunity in this context by judicial decision. A number of states have adopted qualified immunity by judicial decision. See, e.g., Eaton Vance Distrib, Inc. v. Ulrich, 692 So.2d 915, FLADISTCT App 1997, Babarati v. Jose Fall, Lyon, and Ross, Inc., 28 F.3d 704, 7th Sir 1994, Illinois, Andrews v. Prudential Seconds, Inc., 160 F.3d 304, 6th Sir 1998, Michigan, Prudential Seconds, Inc. v. Dalton, 929 F sub 1411, ND Oklahoma 1996, Oklahoma, Glennon v. Dean Witter Reynolds Incorporated, 83 F.3d 132, 6th Sir 1996, Tennessee. Section 508. Criminal penalties. A. Criminal penalties. A person that willfully violates this act, or a rule adopted or order issued under this act, except Section 504 or the notice filing requirements of Section 302 or 405, or that willfully violates Section 505 knowing the statement made to be false or misleading in a material respect, upon conviction, shall be fined not more than $____ or imprisoned not more than ____ years, or both. An individual convicted of violating a rule or order under this act may be fined, but may not be imprisoned, if the individual did not have knowledge of the rule or order. B. Criminal reference not required. The Attorney General or the proper prosecuting attorney with or without a reference from the administrator, may institute criminal proceedings under this act. 130. C. No limitation on other criminal enforcement. This act does not limit the power of the state to punish a person for conduct that constitutes a crime under other laws of the state. Official comments. Prior provisions, 1956 Act Section 409, RUSA Section 604, Securities Exchange Act of 1934 Section 32, A. 1. This section follows the 1956 Act and the federal securities laws in imposing criminal penalties for any willful violation of the Act. RUSA Section 604 distinguished between felonies and misdemeanors, limiting willful violations of cease and desist orders to a misdemeanor. 2. The term willfully has the same meaning in Section 508 as it did in the 1956 Act. All that is required is proof that a person acted intentionally in the sense that the person was aware of what he or she was doing. Proof of evil motive or intent to violate the law or knowledge that the law was being violated is not required. 3. The final sentence of Section 508A is based on Section 32A of the Securities Exchange Act of 1934, which provides, "No person shall be subject to imprisonment under this section in violation of any rule or regulation if he proves that he had no knowledge of such rule or regulation." The no knowledge clause in Section 508A is relevant only to sentencing. The person convicted has the burden of persuasion to prove no knowledge at sentencing. Because this does not impose a burden on the defendant to disprove the elements of a crime, Section 32A of the Securities Exchange Act of 1934 has been held not to raise a constitutional problem. United States v. Mondale, 296 F. Sup. 1038, 1040, SDNY 1969. 4. The appropriate state prosecutor under Section 508B may decide whether to bring a criminal action under the statute, another statute, or, when applicable, common law. In certain states the administrator has full or limited criminal enforcement powers. 5. This section does not specify maximum dollar amounts for criminal fines, maximum terms for imprisonment, nor the years of limitation, but does provide for each state to specify appropriate magnitudes for criminal fines or maximum terms for imprisonment. 6. The definition of willfulness in Comment 2 to Section 508 has been followed by most courts. See, e.g., State v. Hodge, 460 p.2d 596, 604, Kansas 1969, no specific intent is necessary to constitute the offense where one violates the Securities Act except the intent to do the act denounced by the statute. State v. Nagel, 279 N.W.2d 911, 915, SD 1979. It is widely understood that the legislature may forbid the doing of an act and make its commission a crime without regard to the intent or knowledge of the doer. State v. Fries, 337 N.W.2d 398, 405, Nebraska 1983, proof of it. Specific intent, evil motive, or knowledge that the law was being violated is not required to sustain a criminal conviction under a state's blue sky law. People v. Riley, 708 131 p.2d 1359, 1362, Colorado 1985, a person acts knowingly or willfully with respect to conduct when he is aware that his conduct exists. State v. Larson, 865 p.2d 1355, 1358, Utah 1993, willful implies a willingness to commit the act, not an intent to violate the law or to injure another or acquire any advantage. State v. Montgomery, 17 p.3d 292, 294, Idaho 2001, bad faith is not required for a violation of a state securities act. Willful implies simply a purpose or willingness to commit the act or make the omission referred to. State v. Dumke, 901 S.W.2d 100, 102, MOCT App 1995, mens rea not required. State v. Mueller, 549 N.W.2d 455, 460, Wisconsin CT App 1996, Willfulness does not require proof that the defendant acted with intent to defraud or knowledge that the law was violated. United States v. Lilly, 291 F sub 989, 993, SD Texas 1968, no knowledge clause in federal statute not available to defendant claiming lack of knowledge of particular SEC rule. Section 509. Civil liability. A. Securities Litigation Uniform Standards Act. Enforcement of civil liability under this section is subject to the Securities Litigation Uniform Standards Act of 1998. B. Liability of seller to purchaser. A person is liable to the purchaser if the person sells a security in violation of Section 301 or, by means of an untrue statement of a material fact or an omission to state a material fact necessary in order to make the statement made, in light of the circumstances under which it is made, not misleading, the purchaser not knowing the untruth or omission and the seller not sustaining the burden of proof that the seller did not know and, in the exercise of reasonable care, could not have known of the untruth or omission. An action under this subsection is governed by the following: 1. The purchaser may maintain an action to recover the consideration paid for the security, less the amount of any income received on the security, and interest at the legal rate of interest from the date of the purchase, costs and reasonable attorney's fees determined by the court, upon the tender of the security, or for actual damages as provided in paragraph 3. 2. The tender referred to in paragraph 1, may be made any time before entry of 132 judgment. Tender requires only notice in a record of ownership of the security and willingness to exchange the security for the amount specified. A purchaser that no longer owns the security may recover actual damages as provided in paragraph 3. 3. Actual damages in an action arising under this subsection are the amount that would be recoverable upon a tender less the value of the security when the purchaser disposed of it, and interest at the legal rate of interest from the date of the purchase, costs and reasonable attorney's fees determined by the court. C. Liability of purchaser to seller. A person is liable to the seller if the person buys a security by means of an untrue statement of a material fact or omission to state a material fact necessary in order to make the statement made, in light of the circumstances under which it is made, not misleading, the seller not knowing of the untruth or omission, and the purchaser not sustaining the burden of proof that the purchaser did not know, and in the exercise of reasonable care, could not have known of the untruth or omission. An action under this subsection is governed by the following: 1. The seller may maintain an action to recover the security, and any income received on the security, costs and reasonable attorney's fees determined by the court, upon the tender of the purchase price, or for actual damages as provided in paragraph 3. 2. The tender referred to in paragraph 1, may be made any time before entry of judgment. Tender requires only notice in a record of the present ability to pay the amount tendered and willingness to take delivery of the security for the amount specified. If the purchaser no longer owns the security, the seller may recover actual damages as provided in paragraph 3. 133. 3. Actual damages in an action arising under this subsection are the difference between the price at which the security was sold and the value the security would have had at the time of the sale in the absence of the purchaser's conduct causing liability, and interest at the legal rate of interest from the date of the sale of the security, costs and reasonable attorney's fees determined by the court. D. Liability of unregistered broker-dealer and agent. A person acting as a broker-dealer or agent that sells or buys a security in violation of Section 401(a), 402(a), or 506 is liable to the customer. The customer, if a purchaser, may maintain an action for recovery of actual damages as specified in subsections b. 1 through 3, or, if a seller, for a remedy as specified in subsections c. 1 through 3. E. Liability of unregistered investment advisor and investment advisor representative. A person acting as an investment advisor or investment advisor representative that provides investment advice for compensation in violation of Section 403, A, 404, A, or 506 is liable to the client. The client may maintain an action to recover the consideration paid for the advice, interest at the legal rate of interest from the date of payment, costs, and reasonable attorney's fees determined by the court. F. Liability for investment advice. A person that receives directly or indirectly any consideration for providing investment advice to another person and that employs a device, scheme, or artifice to defraud the other person or engages in an act, practice, or course of business that operates or would operate as a fraud or deceit on the other person, is liable to the other person. An action under this subsection is governed by the following. 1. The person defrauded may maintain an action to recover the consideration paid 134 for the advice and the amount of any actual damages caused by the fraudulent conduct, interest at the legal rate of interest from the date of the fraudulent conduct, costs and reasonable attorney's fees determined by the court, less the amount of any income received as a result of the fraudulent conduct. 2. This subsection does not apply to a broker-dealer or its agents if the investment advice provided is solely incidental to transacting business as a broker-dealer and no special compensation is received for the investment advice. G. Joint and several liability. The following persons are liable jointly and severally with and to the same extent as persons liable under subsections B through F. 1. A person that directly or indirectly controls a person liable under subsections B through F, unless the controlling person sustains the burden of proof that the person did not know, and in the exercise of reasonable care could not have known, of the existence of conduct by reason of which the liability is alleged to exist. 2. An individual who is a managing partner, executive officer, or director of a person liable under subsections B through F, including an individual having a similar status or performing similar functions, unless the individual sustains the burden of proof that the individual did not know and, in the exercise of reasonable care could not have known, of the existence of conduct by reason of which the liability is alleged to exist. 3. An individual who is an employee of or associated with a person liable under subsections B through F, and who materially aids the conduct giving rise to the liability, unless the individual sustains the burden of proof that the individual did not know and, in the exercise of reasonable care could not have known, of the existence of conduct by reason of which the 135 liability is alleged to exist, and 4. A person that is a broker-dealer, agent, investment advisor, or investment advisor representative that materially aids the conduct giving rise to the liability under subsections B through F, unless the person sustains the burden of proof that the person did not know and, in the exercise of reasonable care could not have known, of the existence of conduct by reason of which liability is alleged to exist. H. Right of contribution. A person liable under this section has a right of contribution as in cases of contract against any other person liable under this section for the same conduct. I. Survival of cause of action. A cause of action under this section survives the death of an individual who might have been a plaintiff or defendant. J. Statute of limitations. A person may not obtain relief, 1. Under subsection B, for violation of section 301, or under subsection D, or E, unless the action is instituted within 1 year after the violation occurred, or 2. Under subsection B, other than for violation of section 301, or under subsection C, or F, unless the action is instituted within the earlier of 2 years after discovery of the facts constituting the violation and 5 years after the violation. K. No enforcement of violative contract. A person that has made, or has engaged in the performance of, a contract in violation of this act or a rule adopted or order issued under this act, or that has acquired a purported right under the contract with knowledge of conduct by reason of which its making or performance was in violation of this act, may not base an action on the contract. L. No contractual waiver. A condition, stipulation, or provision binding a person 136 purchasing or selling a security or receiving investment advice to waive compliance with this act or a rule adopted or order issued under this act is void. M. Survival of other rights or remedies. The rights and remedies provided by this act are in addition to any other rights or remedies that may exist, but this act does not create a cause of action not specified in this section or section 411, e. Official comments. Prior provisions, 1956 Act Section 410, RUSA Section 605 to 607, 609, 802. 1. Under Section 509 violations of 2 or more sections can be proven, but the remedy is limited either to rescission or actual damages. Actual damages means compensatory damages. Punitive or double damages are not provided by this section, which also is the standard under Section 28A of the Securities Exchange Act of 1934. C9 Lewis Loss and Joel Seligman, Securities Regulation 4408 to 4427, 3D ed. Rev. 1992. 2. The Securities Litigation Uniform Standards Act of 1998, cited in Section 509A, modifies the entire Section 509. 3. As with Section 12A, 2, of the Securities Act of 1933, Section 509B, contains a type of privity requirement in that the purchaser is required to bring an action against the seller. Section 509B is broader than Section 12A, 2, in that it will reach all sales in violation of Section 301, not just sales by means of a prospectus as is the law under Section 12A, 2. See Gustafson v. Alloydco, Inc., 513 U.S. 561, 1995. 4. Unlike the current standards on implied rights of action under Rule 10b-5, neither causation nor reliance has been held to be an element of a private cause of action under the precursor to Section 509b. See Gerhard W. Gohler, IRAB Wood, 919 p.2d 561, Utah 1996, Rich v. Robinson Humpreco, 748 so. 2d 861, Alla 1999, Kaufman v. ISTAT Corp., 754 A.2d 1188, NJ 2000. 5. The measure of damages in Section 509b, 3, is that contemplated by Section 12 of the Securities of 1933. C9 Lewis Loss and Joel Seligman, Securities Regulations 4242 to 4246, 3D ed. 1992. The measure of damages in Section 509, c. 3, however, is that contemplated by Rule 10b-5. Sector 9 ID 4408 to 4427. In providing for damages as an alternative to rescission, Section 509b, 3, follows the 1956 Act and is an improvement upon many earlier state provisions, which condition the plaintiff's right of recovery on his or her being in a position to make a good tender. A plaintiff is not given the right under this type of statutory formula to retain stock and also seek damages. 137.6. Sections 509, E, and F, are based on a proposed NASAA amendment to the Uniform Securities Act adopted in order to establish civil liability for individuals who willfully violate Section 102 dealing with fraudulent practices pertaining to advisory activities. Neither provision is intended to limit other state law claims for providing investment advice. 7. Broker-dealer employees, including research analysts, who receive no special compensation from third parties for investment advice would not be liable under Section 509, F. 8. The control liability provision in Section 509, G, 1, is modeled on that in the 1956 Act. On the meaning of control, see 4 Lewis Loss and Joel Seligman, Securities Regulations 1703-1727, 3D ed. Rev. 2000. 9. The defense of lack of knowledge in Sections 509, G, is also modeled on the 1956 Act. 10 under Section 509, G. 2. Partners, officers, and directors are liable, subject to the defense afforded by that subsection, without proof that they aided in the sale. In Section 509, G. 2, the term partner is intended to be limited to partners with management responsibilities, rather than a partner with a passive investment. 11 under 509, G. 4, the performance by a clearing broker of the clearing broker's contractual functions, even though necessary to the processing of a transaction, without more would not constitute material aid or result in liability under this subsection. See, e.g., Ross v. Bolton, 904 F.2d 819, 2d Sir 1990. 12. The reasonable attorney's fees specified in Section 509 are permissive, not mandatory. See, e.g., Andrews v. Blue, 489 F.2d 367, 377, 10th Sir 1973, Colorado Statute. 13. The contribution provision in Section 509, H, is a safeguard to avoid the common law principle that prohibited contribution among joint tortfeasors. 14. The statute of limitations in Section 509, J, is a hybrid of the 1956 Act and federal securities law approaches. The 1956 Act Section 410, p, provided that, no person may sue under this section more than 2 years after the contract of sale. Under this provision, the state courts generally decline to extend a statute of limitations period on grounds of fraudulent concealment or equitable tolling. Before the July 2002 enactment of the Sarbanes-Oxley Act, Rule 10b-5 of the Securities Exchange Act as construed by the United States Supreme Court in Lamp, Pleva, Lipkind, Prepes, and Pettigrew v. Gilbertson, 501 U.S. 350, 1991, prohibited equitable tolling under the federal securities law 1 year after discovery and 3 years after the Act formula. See generally 10 Lewis Loss and Joel Seligman, Securities Regulation 4505-4525, 3D ed. Rev. 1996. The Sarbanes-Oxley Act added 28 U.S.C. 1658, b, which provides 138 a private right of action that involves a claim of fraud, deceit, manipulation, or contrivance in contravention of a regulatory requirement concerning the securities laws, as defined in Section 3, a, 47, of the Securities Exchange Act of 1934, 15 U.S.C. 78 c, a, 47, may be brought not later than the earlier of 1, 2 years after the discovery of the facts constituting the violation, or 2, 5 years after such violation. Section 509, J, 1, as with the 1956 Act, is a unitary statute of repose, requiring an action to be commenced within 1 year after a violation occurred. It is not intended that equitable tolling be permitted. Section 509, J, 2, in contrast, generally follows the federal securities law model. An action must be brought within the earlier of 2 years after discovery or 5 years after the violation. As with federal courts construing the statute of limitations under Rule 10b-5, it is intended that the plaintiff's right to proceed is limited to 2 years after actual discovery or after such discovery should have been made by the exercise of reasonable diligence, inquiry notice, c, e.g., Law v. Medco Research, Inc., 113 F.3d 781, 7th Sir 1997, or 5 years after the violation. The rationale for replicating the basic federal statute of limitations in this act is to discourage forum shopping. If the statute of limitations applicable to Rule 10b-5 were to be changed in the future, identical changes should be made in Section 509, J, 2. 15. Section 509, K, is similar to Section 29, B, of the Securities Exchange Act and is intended to apply only to actions to enforce illegal contracts. See Lewis Loss, Commentary on the Uniform Securities Act 150, 1976. 16. Section 509, M, follows the 1956 Act. 17 Section 509 and Section 411, e, provide the exclusive private causes of action under this Act. Section 510. Rescission offers. A purchaser, seller, or recipient of investment advice may not maintain an action under Section 509 if 1. The purchaser, seller, or recipient of investment advice receives in a record, before the action is instituted, 139, a. An offer stating the respect in which liability under Section 509 may have arisen and fairly advising the purchaser, seller, or recipient of investment advice of that person's rights in connection with the offer, and any financial or other information necessary to correct all material misrepresentations or omissions in the information that was required by this Act to be furnished to that person at the time of the purchase, sale, or investment advice. b. If the basis for relief under this section may have been a violation of Section 509, b. An offer to repurchase the security for cash, payable on delivery of the security, equal to the consideration paid, and interest at the legal rate of interest from the date of the purchase, less the amount of any income received on the security, or, if the purchaser no longer owns the security, an offer to pay the purchaser upon acceptance of the offer damages in an amount that would be recoverable upon a tender, less the value of the security when the purchaser disposed of it, and interest at the legal rate of interest from the date of the purchase in cash equal to the damages computed in the manner provided in this subsection. c. If the basis for relief under this section may have been a violation of Section 509, c. An offer to tender the security, on payment by the seller of an amount equal to the purchase price paid, less income received on the security by the purchaser and interest at the legal rate of interest from the date of the sale, or if the purchaser no longer owns the security, an offer to pay the seller upon acceptance of the offer, in cash, damages in the amount of the difference between the price at which the security was purchased and the value the security would have had at the time of the purchase in the absence of the purchaser's conduct that may have caused liability and interest at the legal rate of interest from the date of the sale. d. If the basis for relief under this section may have been a violation of Section 14509, d. And if the customer is a purchaser, an offer to pay as specified in subparagraph b, or, if the customer is a seller, an offer to tender or to pay as specified in subparagraph c, e. If the basis for relief under this section may have been a violation of Section 509, e. An offer to reimburse in cash the consideration paid for the advice and interest at the legal rate of interest from the date of payment, or, f. If the basis for relief under this section may have been a violation of Section 509, f. An offer to reimburse in cash the consideration paid for the advice, the amount of any actual damages that may have been caused by the conduct, and interest at the legal rate of interest from the date of the violation causing the loss. 2. The offer under paragraph 1 states that it must be accepted by the purchaser, seller, or recipient of investment advice within 30 days after the date of its receipt by the purchaser, seller, or recipient of investment advice or any shorter period, of not less than 3 days, that the administrator, by order, specifies. 3. The offerer has the present ability to pay the amount offered or to tender the security under paragraph 1. 4. The offer under paragraph 1 is delivered to the purchaser, seller, or recipient of investment advice, or sent in a manner that ensures receipt by the purchaser, seller, or recipient of investment advice, and 5. The purchaser, seller, or recipient of investment advice that accepts the offer under paragraph 1, in a record within the period specified under paragraph 2, is paid in accordance with the terms of the offer. Official Comments 141 Prior Provisions, 1956 Act Section 410, e. Rusas Section 607. 1. A rescission offer must meet the specific requirements of Section 510 for civil liability under Section 509 to be extinguished. Cf. Binder v. Gordian Seconds, Inc., 742 F sub 663, 666, NDGA 1990. See generally Roe, rescission offers under federal and state securities law. 12 J Corp L 383, 1987. 2. A rescission offer that does not comply with Section 510 is subject to civil liability, administrative enforcement, or criminal penalties under this Act. A rescission offer, for example, could violate Section 501, the general fraud provision. 3. The administrator may publish a form that would comply with Section 510, but the form would not be the only one that could be used by the parties. 4. A valid rescission offer will be exempt from securities registration. See Section 202, 19. 5. If a state chooses to add a notice or filing provision, it could provide this provision in Section 510, 6, which would state, 6. The offer or a notice is required to be filed with the administrator 10 business days before the offering and conform in form and content with a rule prescribed by the administrator. 142 Article 6 Administration and Judicial Review Section 601. Administration. A. Administration. The administrator shall administer this Act. Insert any related provisions on such matters as method of selection, salary, term of office, selection, and remuneration of personnel, and annual reports to the legislature or governor that are appropriate to the particular state. B. Unlawful use of records or information. It is unlawful for the administrator or an officer, employee, or designee of the administrator to use for personal benefit or the benefit of others records or other information obtained by or filed with the administrator that are not public under Section 607, b. This Act does not authorize the administrator or an officer, employee, or designee of the administrator to disclose the record or information, except in accordance with Section 602, 607, c, or 608. c. No privilege or exemption created or diminished. This Act does not create or diminish a privilege or exemption that exists at common law, by statute, or rule, or otherwise. D. Investor education. The administrator may develop and implement investor education initiatives to inform the public about investing in securities, with particular emphasis on the prevention and detection of securities fraud. In developing and implementing these initiatives, the administrator may collaborate with public and non-profit organizations with an interest in investor education. The administrator may accept a grant or donation from a person that is not affiliated with the securities industry or from a non-profit organization, regardless of 143 whether the organization is affiliated with the securities industry, to develop and implement investor education initiatives. This subsection does not authorize the administrator to require participation or monetary contributions of a registrant in an investor education program. E. The Securities Investor Education and Training Fund. The Securities Investor Education and Training Fund is created to provide funds for the purposes specified in subsection D. All monies received by the state by reason of civil penalties pursuant to this Act shall be deposited in the Securities Investor Education and Training Fund. The state may insert any other provision concerning appropriations to support this fund as well as procedures for its operations. Official comments. Prior provisions, 1956 Act Section 406, RUSA Section 701 to 702. 1. Section 601, b, should be read with Section 607. Section 601, b, prohibits the administrator or the administrator's officers and employees from using for personal benefit records or information that Section 607, b, specifies do not constitute public records. Section 601, b, is not intended to limit the operation of Section 607, a. Neither Section 601, b, nor 607, b, is intended to impede the ability of the agencies specified in Section 608, a, from sharing records or other information in connection with an examination or an investigation. 2. Section 601, c, makes clear that nothing in this Act alters the availability of evidentiary privileges. That question is left to the general law of the particular state. 3. Section 601, d, and e, were adopted in recognition of the importance of investor education. An increasing number of jurisdictions are earmarking specific funds for this purpose. The lack of financial acumen among public investors, seniors, and students continues to be demonstrated in recent industry and regulatory studies. The importance of investor financial literacy is increasingly crucial given the decades-long shift from defined benefit retirement plans toward defined contribution plans where employees are left to direct their own retirement accounts. Section 602. Investigations and subpoenas. A. Authority to investigate. The administrator may, 144, 1. Conduct public or private investigations within or outside of the state which the administrator considers necessary or appropriate to determine whether a person has violated, is violating, or is about to violate this act or a rule adopted or order issued under this act, or to aid in the enforcement of this act or in the adoption of rules and forms under this act. 2. Require or permit a person to testify, file a statement, or produce a record, under oath, or otherwise as the administrator determines, as to all the facts and circumstances concerning a matter to be investigated or about which an action or proceeding is to be instituted, and 3. Publish a record concerning an action, proceeding, or an investigation under, or a violation of, this act or a rule adopted or order issued under this act if the administrator determines it is necessary or appropriate in the public interest and for the protection of investors. B. Administrator powers to investigate. For the purpose of an investigation under this act, the administrator or its designated officer may administer oaths and affirmations, subpoena witnesses, seek compulsion of attendance, take evidence, require the filing of statements, and require the production of any records that the administrator considers relevant or material to the investigation. C. Procedure and remedies for non-compliance. If a person does not appear or refuses to testify, file a statement, produce records, or otherwise does not obey a subpoena as required by the administrator under this act, the administrator may refer the matter to the Attorney General or the proper attorney, who may apply to insert name of the appropriate court or a court of another state to enforce compliance. The court may, 1. Hold the person in contempt, 2. Order the person to appear before the administrator, 145, 3. Order the person to testify about the matter under investigation or in question, 4. Order the production of records, 5. Grant injunctive relief, including restricting or prohibiting the offer or sale of securities or the providing of investment advice, 6. Impose a civil penalty of not less than $_ and not greater than $_ for each violation, and 7. Grant any other necessary or appropriate relief. D. Application for relief. This section does not preclude a person from applying to insert name of appropriate court or a court of another state for relief from a request to appear, testify, file a statement, produce records, or obey a subpoena. E. Use immunity procedure. An individual is not excused from attending, testifying, filing a statement, producing a record or other evidence, or obeying a subpoena of the administrator under this act or in an action or proceeding instituted by the administrator under this act on the ground that the required testimony, statement, record, or other evidence, directly or indirectly, may tend to incriminate the individual or subject the individual to a criminal fine, penalty, or forfeiture. If the individual refuses to testify, file a statement, or produce a record or other evidence on the basis of the individual's privilege against self-incrimination, the administrator may apply to the name of the appropriate court to compel the testimony, the filing of the statement, the production of the record, or the giving of other evidence. The testimony, record, or other evidence compelled under such an order may not be used, directly or indirectly, against the individual in a criminal case, except in a prosecution for perjury or contempt or otherwise failing to comply with the order. 146, f. Assistance to securities regulator of another jurisdiction. At the request of the securities regulator of another state or a foreign jurisdiction, The administrator may provide assistance if the requesting regulator states that it is conducting an investigation to determine whether a person has violated, is violating, or is about to violate a law or rule of the other state or foreign jurisdiction relating to securities matters that the requesting regulator administers or enforces. The administrator may provide the assistance by using the authority to investigate and the powers conferred by this section as the administrator determines is necessary or appropriate. The assistance may be provided without regard to whether the conduct described in the request would also constitute a violation of this act or other law of the state if occurring in this state. In deciding whether to provide the assistance, the administrator may consider whether the requesting regulator is permitted and has agreed to provide assistance reciprocally within its state or foreign jurisdiction to the administrator on securities matters when requested, whether compliance with the request would violate or prejudice the public policy of the state, and the availability of resources and employees of the administrator to carry out the request for assistance. Official comments. Prior provisions, 1956 Act Section 407, RUSA Section 601. 1 Section 602, A, and B, follow the 1956 Act, which was modeled generally on Sections 21, A, through D, of the Securities Exchange Act of 1934 as it then read. 2 standards for issuance of subpoenas have been generally established in federal and state securities law. C, e.g., 10 Lewis Loss and Joel Seligman, Securities Regulation 4917-4937, 3D Ed Rev 1996, discussing Oklahoma Press Pub Co v. Walling, 327 U.S. 186, 1946, and other cases. The scope of subpoena enforcement in each state is a general matter for judicial determination. Under Section 602, an individual subpoenaed to testify by the administrator is not compelled to testify within the meaning of these sections simply by service of a subpoena. Under Section 602, b, the individual can be subpoenaed and compelled to attend. Once in attendance, an individual can assert an evidentiary privilege or exemption, see Section 601, c, including the 147 Fifth Amendment privilege against self-incrimination. If an individual refuses to testify or give evidence, the administrator may apply, or have the appropriate state attorney apply, to the appropriate court for the relief specified in Section 602, c. If the individual invokes the privilege against self-incrimination, Section 602, d, allows the administrator to apply to the appropriate court to compel testimony under the use immunity provision barring the record compelled or other evidence obtained from being used in a criminal case. See People v. District Co. of Arapahoe County, 894 p.2 d 739, Colorado 1995. The phrase directly or indirectly in Section 602, e, is intended to include testimony, other evidence, or other information derived from immunized testimony, statements, records, or evidence. 3. Section 602 is intended to apply generally to securities offers and sales under Article 3 and broker-dealer and investment advisor activity under Article 4, when there is non-compliance with the first sentence of Section 602, c. This subsection does not limit the powers of an administrator under other provisions of this Act. 4. A court may quash a subpoena for good cause under Section 602, d. The court may decline to enforce a subpoena that is arbitrary, capricious, or oppressive. 5. Where appropriate under Section 602, f, an administrator could move to authorize admission of a requesting state's attorney under existing pro-HAC vice rules. 6. Section 602, f, is consistent with the Securities Litigation Uniform Standard Act of 1998, which provides in Section 102, e, the Securities and Exchange Commission, in consultation with state securities commissions, or any agencies or offices performing like functions, shall seek to encourage the adoption of state laws providing for reciprocal enforcement by state securities commissions of subpoenas issued by another state securities commission seeking to compel persons to attend, testify in, or produce documents or records in connection with an action or investigation by a state securities commission of an alleged violation of state securities laws. 7. There are limitations on financial institutions being subject to visitorial powers by state officials, such as those affecting national banks contained in 12 U.S.C. 484 and 12 CFR Sector 7.4000. Law outside this act may place similar limits on state-chartered financial institutions being subjected to visitorial powers. This act does not negate these limitations. Section 603. Civil enforcement. A. Civil action instituted by administrator. If the administrator believes that a person has engaged, is engaging, or is about to engage in an act, practice, or course of business 148 constituting a violation of this act or a rule adopted or order issued under this act, or that a person has, is, or is about to engage in an act, practice, or course of business that materially aids a violation of this act or a rule adopted or order issued under this act, the administrator may maintain an action in the insert the name of the court to enjoin the act, practice, or course of business and to enforce compliance with this act or a rule adopted or order issued under this act. B. Relief available. In an action under this section and on a proper showing, the court may, 1. Issue a permanent or temporary injunction, restraining order, or declaratory judgment. 2. Order other appropriate or ancillary relief, which may include, a. An asset freeze, accounting, writ of attachment, writ of general or specific execution, and appointment of a receiver or conservator, that may be the administrator, for the defendant or the defendant's assets. B. Ordering the administrator to take charge and control of a defendant's property, including investment accounts and accounts in a depository institution, rents, and profits, to collect debts, and to acquire and dispose of property. C. Imposing a civil penalty up to $_ for a single violation or up to $_ for more than one violation, an order of rescission, restitution, or disgorgement directed to a person that has engaged in an act, practice, or course of business constituting a violation of this act or the predecessor act or a rule adopted or order issued under this act or the predecessor act, and d. Ordering the payment of prejudgment and post-judgment interest, or 3. Order such other relief as the court considers appropriate. 149. C. No bond required. The administrator may not be required to post a bond in an action or proceeding under this act. Official comments. Prior provisions, 1956 Act Section 408, RUSA Section 603(1). Section 408 of the 1956 Act was limited to injunctions. This section follows RUSA in broadening the civil remedies available when the administrator believes that a violation has occurred. A primary purpose of a broad range of potential sanctions is to enable administrators to better tailor appropriate sanctions to particular misconduct. 2. The administrator alternatively may proceed to seek administrative enforcement under Section 604, to deny, suspend, or revoke a securities registration under Section 306, or to deny, suspend, revoke, or take other action against a broker-dealer, agent, investment advisor, or investment advisor representative registration under Section 412. 3. Constitutional due process considerations can also be addressed by rulemaking or incorporation of the applicable Administrative Procedure Act provisions of each jurisdiction. The term "upon a proper showing" has a settled meaning in the federal securities laws. See, e.g., Securities Act of 1933 Section 20, b. 4 as with Sections 509, g. 3, and 4, materially aid in Section 603, a, does not include ministerial or clerical acts. Section 604. Administrative enforcement. A. Issuance of an order or notice. If the administrator determines that a person has engaged, is engaging, or is about to engage in an act, practice, or course of business constituting a violation of this act or a rule adopted or order issued under this act, or that a person has materially aided, is materially aiding, or is about to materially aid an act, practice, or course of business constituting a violation of this act or a rule adopted or order issued under this act, the administrator may, 1. Issue an order directing the person to cease and desist from engaging in the act, 150 practice or course of business, or to take other action necessary or appropriate to comply with this act. 2. Issue an order denying, suspending, revoking, or conditioning the exemptions for a broker-dealer under Section 401, B, 1, D, or F, or an investment advisor under Section 403, B, 1, C, or 3. Issue an order under Section 204. B. Summary process. An order under subsection A is effective on the date of issuance. Upon issuance of the order, the administrator shall promptly serve each person subject to the order with a copy of the order and a notice that the order has been entered. The order must include a statement whether the administrator will seek a civil penalty or costs of the investigation, a statement of the reasons for the order, and notice that, within 15 days after receipt of a request in a record from the person, the matter will be scheduled for a hearing. If a person subject to the order does not request a hearing and none is ordered by the administrator within 30 days after the date of service of the order becomes final as to that person by operation of law. If a hearing is requested or ordered, the administrator, after notice of an opportunity for hearing to each person subject to the order, may modify or vacate the order or extend it until final determination. C. Procedure for final order. If a hearing is requested or ordered pursuant to subsection B, a hearing must be held pursuant to the State Administrative Procedure Act. A final order may not be issued unless the administrator makes findings of fact and conclusions of law in a record in accordance with the State Administrative Procedure Act. The final order may make final, vacate, or modify the order issued under subsection A. 151, D. Civil penalty. In a final order under subsection C, the administrator may impose a civil penalty up to $1 for a single violation or up to $1 for more than one violation. E. Costs. In a final order, the administrator may charge the actual cost of an investigation or proceeding for a violation of this Act or a rule adopted or order issued under this Act. F. Filing of certified final order with court, effect of filing. If a petition for judicial review of a final order is not filed in accordance with Section 609, the administrator may file a certified copy of the final order with the clerk of a court of competent jurisdiction. The order so filed has the same effect as a judgment of the court and may be recorded, enforced, or satisfied in the same manner as a judgment of the court. G. Enforcement by court, further civil penalty. If a person does not comply with an order under this section, the administrator may petition a court of competent jurisdiction to enforce the order. The court may not require the administrator to post a bond in an action or proceeding under this section. If the court finds, after service and opportunity for hearing, that the person was not in compliance with the order, the court may adjudge the person in civil contempt of the order. The court may impose a further civil penalty against the person for contempt in an amount not less than $1 but not greater than $1 for each violation, and may grant any other relief the court determines is just and proper in the circumstances. Official comments. Prior provisions, RUSA Section 602, 712. 1. Section 604, unlike Section 603, may be initiated by the administrator without prior judicial process or a prior hearing. The section, among other matters, empowers the administrator to act summarily in appropriate circumstances. 152(2). Section 603 and 604 are intended to be available to the administrator against persons not subject to stop orders under Section 306 or proceedings against registered broker-dealers, agents, investment advisors, or investment advisor representatives under Section 412. All persons or securities not subject to Section 306 or 412 will be subject to Section 603 and 604. A person must be covered by either 1. Sections 306 or 412 or 2. Section 603 or 604. 3. Service of an order or notice under this section is not effective unless made in accordance with Section 611. Section 605. Rules, forms, orders, interpretative opinions, and hearings. A. Issuance and adoption of forms, orders, and rules. The administrator may, 1. Issue forms and orders and, after notice and comment, may adopt and amend rules necessary or appropriate to carry out this act and may repeal rules, including rules and forms governing registration statements, applications, notice filings, reports, and other records. 2. By rule, define terms, whether or not used in this act, but those definitions may not be inconsistent with this act, and 3. By rule, classify securities, persons, and transactions and adopt different requirements for different classes. B. Findings and cooperation. Under this act, a rule or form may not be adopted or amended, or an order issued or amended, unless the administrator finds that the rule, form, order, or amendment is necessary or appropriate in the public interest or for the protection of investors and is consistent with the purposes intended by this act. In adopting, amending, and repealing rules and forms, Section 608 applies in order to achieve uniformity among the states and coordination with federal laws in the form and content of registration statements, applications, reports, and other records, including the adoption of uniform rules, forms, and 153 procedures. C. Financial statements. Subject to Section 15, H, of the Securities Exchange Act and Section 222 of the Investment Advisors Act of 1940, the administrator may require that a financial statement filed under this act be prepared in accordance with generally accepted accounting principles in the United States and comply with other requirements specified by rule adopted or order issued under this act. A rule adopted or order issued under this act may establish, 1. Subject to Section 15, H, of the Securities Exchange Act and Section 222 of the Investment Advisors Act of 1940, the form and content of financial statements required under this act. 2. Whether unconsolidated financial statements must be filed, and 3. Whether required financial statements must be audited by an independent certified public accountant. D. Interpretative opinions. The administrator may provide interpretative opinions or issue determinations that the administrator will not institute a proceeding or an action under this act against a specified person for engaging in a specified act, practice, or course of business if the determination is consistent with this act. A rule adopted or order issued under this act may establish a reasonable charge for interpretative opinions or determinations that the administrator will not institute an action or a proceeding under this act. E. Effect of compliance. A penalty under this act may not be imposed for, and liability does not arise from conduct that is engaged in or omitted in good faith believing it conforms to a rule, form, or order of the administrator under this act. 154. F. Presumption for public hearings. A hearing in an administrative proceeding under this act must be conducted in public unless the administrator for good cause consistent with this act determines that the hearing will not be so conducted. Official comments. Prior provisions, 1956 Act Section 412, RUSA Section 705, 707. 1. It is anticipated that the administrator will propose amendments or make rules under Section 605, A, to remain coordinate with relevant federal law, as well as appropriate rules of the National Association of Securities Dealers, and to achieve uniformity among the states. 2. Uniform forms such as Form BD, U4, U5, and NF are today common in the securities industry and are authorized by Section 605, B. 3. Section 605, C, refers to generally accepted accounting principles in the United States which currently are promulgated by the Financial Accounting Standards Board and the Securities and Exchange Commission. 4. It is anticipated that the states will employ websites, email, or other electronic means to provide notice of proposed rulemaking or adoption of new rules, rule amendments, forms or form amendments, statements of policy or interpretations adopted by the administrator, and issuance of orders to registrants and others who have provided a current email or similar address and expressed an interest in receiving such notice. 5. Section 605(e) does not apply to staff no action or interpretative opinions, but does apply to rules, forms, orders, statements of policy or interpretations adopted by the administrator. Section 606. Administrative files and opinions. A. Public Register of Filings. The administrator shall maintain, or designate a person to maintain, a register of applications for registration of securities, registration statements, notice filings, applications for registration of broker-dealers, agents, investment advisors, and investment advisor representatives, notice filings by federal covered investment advisors that are or have been effective under this Act or the predecessor Act, notices of claims of Exemption 155 from registration or notice filing requirements contained in a record, orders issued under this Act or the predecessor Act, and interpretative opinions or no action determinations issued under this Act. B. Public availability. The administrator shall make all rules, forms, interpretative opinions, and orders available to the public. C. Copies of public records. The administrator shall furnish a copy of a record that is a public record or a certification that the public record does not exist to a person that so requests. A rule adopted under this Act may establish a reasonable charge for furnishing the record or certification. A copy of the record certified or a certificate by the administrator of a record's non-existence is prima facie evidence of a record or its non-existence. Official comments. Prior provisions, 1956 Act Section 413, RUSA Section 709. 1. Record is defined in Section 102(25). 2. Compliance with a state records law will typically satisfy the requirements of Section 606(a). Section 607. Public records, confidentiality. A. Presumption of public records. Except as otherwise provided in subsection B, records obtained by the administrator or filed under this Act, including a record contained in or filed with a registration statement, application, notice filing, or report, are public records and are available for public examination. B. Non-public records. The following records are not public records and are not 156 available for public examination under subsection A. 1. A record obtained by the administrator in connection with an audit or inspection under Section 411, d, or an investigation under Section 602, 2, a part of a record filed in connection with a registration statement under Sections 301 and 303 through 305 or a record under Section 411, d, that contains trade secrets or confidential information if the person filing the registration statement or report has asserted a claim of confidentiality or privilege that is authorized by law. 3. A record that is not required to be provided to the administrator or filed under this Act and is provided to the administrator only on the condition that the record will not be subject to public examination or disclosure. 4. A non-public record received from a person specified in Section 608(a), and 5. Any social security number, residential address, and residential telephone number contained in a record that is filed, and 6. A record obtained by the administrator through a designee of the administrator that a rule or order under this Act determines has been, a. expunged from the administrator's records by the designee, or b. determined to be non-public or non-disclosable by that designee if the administrator finds the determination to be in the public interest and for the protection of investors. C. Administrator discretion to disclose. If disclosure is for the purpose of a civil, administrative, or criminal investigation, action, or proceeding or to a person specified in Section 608(a), the administrator may disclose a record obtained in connection with an audit or 157 inspection under Section 411(d), or a record obtained in connection with an investigation under Section 602. Official comments. Prior provisions, RUSA Section 703, SEC Rule Section 200.80, b, 4. Securities Exchange Act of 1934 Sections 24, d, and e. 1 Section 607, a, reflects the extensive development of freedom of information and open records laws since the 1956 Act was adopted. 2 Section 607, b, may insulate from public disclosure records or other information that may be available under a State Freedom of Information or Open Records Act. Unless the State Freedom of Information or Open Records Act implements a constitutional provision, this Act as the later and more specific enactment should control as a matter of statutory construction. A state may amend its Freedom of Information Act, Open Records Act or this section to eliminate any inconsistencies. 3. Records and other information obtained by an administrator in connection with an audit or inspection under subsection 411, d, or an investigation under section 602 may be made public in the enforcement action, even if records and other information would otherwise be subject to subsection 607, b, 1. 4. An administrator may orally disclose information under section 607, c, to a person specified in section 608, a, for the purposes specified in section 607, c. Section 608. Uniformity and cooperation with other agencies. A. Objective of uniformity. The administrator shall, in its discretion, cooperate, coordinate, consult, and, subject to section 607, share records and information with the securities regulator of another state, Canada, a Canadian province or territory, a foreign jurisdiction, the Securities and Exchange Commission, the United States Department of Justice, the Commodity Futures Trading Commission, the Federal Trade Commission, the Securities Investor Protection Corporation, a self-regulatory organization, a national or international organization of securities regulators, a federal or state banking and insurance regulator, and a governmental Law 158 enforcement agency to effectuate greater uniformity in securities matters among the federal government, self-regulatory organizations, states, and foreign governments. B. Policies to consider. In cooperating, coordinating, consulting, and sharing records and information under this section and in acting by rule, order, or waiver under this Act, the administrator shall, in its discretion, take into consideration in carrying out the public interest the following general policies: 1. Maximizing effectiveness of regulation for the protection of investors. 2. Maximizing uniformity in federal and state regulatory standards. And 3. Minimizing burdens on the business of capital formation, without adversely affecting essentials of investor protection. C. Subjects for cooperation. The cooperation, coordination, consultation, and sharing of records and information authorized by this section includes: 1. Establishing or employing one or more designees as a central depository for registration and notice filings under this Act and for records required or allowed to be maintained under this Act. 2. Developing and maintaining uniform forms. 3. Conducting a joint examination or investigation. 4. Holding a joint administrative hearing. 5. Instituting and prosecuting a joint civil or administrative proceeding. 6. Sharing and exchanging personnel. 7. Coordinating registrations under sections 301 and 401 through 404 and exemptions under section 203, 159. 8. Sharing and exchanging records, subject to section 607. 9. Formulating rules, statements of policy, guidelines, forms, and interpretative opinions and releases. 10. Formulating common systems and procedures. 11. Notifying the public of proposed rules, forms, statements of policy, and guidelines. 12. Attending conferences and other meetings among securities regulators, which may include representatives of governmental and private sector organizations involved in capital formation, deemed necessary or appropriate to promote or achieve uniformity. And 13. Developing and maintaining a uniform exemption from registration for small issuers, and taking other steps to reduce the burden of raising investment capital by small businesses. Official comments. Prior provisions, 1956 Act Section 415, RUSA Section 704 and 803, 19, c. of the Securities Act of 1933. 1. Uniformity of regulation among the states and coordination with the Securities and Exchange Commission is a principal objective of this Act. Section 608 is intended to encourage such cooperation to the maximum extent appropriate. Operative phrases such as shall, in its discretion in Section 608, a, and, b, are intended to be precisely coordinate with the directive that Congress gave to the Securities and Exchange Commission in Section 19, c, of the Securities Act of 1933. 2. The goals of uniformity among the states and coordination with related federal regulation, including self-regulatory organizations, may be enhanced by greater use of information technology systems such as the Web CRD, the Investment Advisor Registration Depository, IARD, or the Securities and Exchange Commission Electronic Data Gathering, Analysis, and Retrieval System, EDGAR. These types of techniques are consistent with a potential system of one-stop filing of all federal and state forms that is encouraged by this Act. 3. This Act is intended, to the extent practicable, to be revenue neutral in its impact on 160 existing state laws. 4. Section 608, c, lists some joint or coordinated efforts which might be undertaken. Other appropriate cooperative activities are also encouraged. 5. Court decisions interpreting the securities laws have construed these acts to achieve broad protection to investors, a remedial approach that embodies a flexible rather than a static principle, one that is capable of adaptation to meet the countless and variable schemes devised by those who seek to use the money of others on the promise of profits. SEC v. W.J. Howe CO. 328 U.S. 293, 299, 301, 1946. Section 609. Judicial Review. A. Judicial Review of Orders. A final order issued by the Administrator under this Act is subject to judicial review in accordance with the State Administrative Procedure Act. B. Judicial Review of Rules. A rule adopted under this Act is subject to judicial review in accordance with the State Administrative Procedure Act. Official comments. Prior provisions, 1956 Act Section 411, RUSA Section 711, b. 1. The 1956 Act Section 411 specified procedures for judicial review of orders, in part modeled on Section 12 of the Model Administrative Procedure Act, 54 Handbook of National Conference of Commissioners on Uniform State Laws 334, 1944, and partly on Section 25 of the Securities Exchange Act. 2. A rule adopted under this Act may be subject to judicial review in accordance with the State Administrative Procedure Act. 3. In those states in which judicial review of rules is permitted, a state may choose to add Section 609, b. In those states in which judicial review of rules is not permitted, Section 609, b, should be deleted. Section 610. Jurisdiction. A. Sales and offers to sell. Sections 301, 302, 401, a, 402, a, 403, a, 404, a, 501, 506, 161, 509, and 510 do not apply to a person that sells or offers to sell a security unless the offer to sell or the sale is made in the state or the offer to purchase or the purchase is made and accepted in the state. B. Purchases and offers to purchase. Sections 401, a, 402, a, 403, a, 404, a, 501, 506, 509, and 510 do not apply to a person that purchases or offers to purchase a security unless the offer to purchase or the purchase is made in the state or the offer to sell or the sale is made and accepted in the state. C. Offers in this state. For the purpose of this section, an offer to sell or to purchase a security is made in the state, whether or not either party is then present in the state, if the offer, 1. originates from within the state, or, 2, is directed by the offerer to a place in the state and received at the place to which it is directed. D. Acceptances in the state. For the purpose of this section, an offer to purchase or to sell is accepted in the state, whether or not either party is then present in the state, if the acceptance, 1, is communicated to the offerer in the state and the offeree reasonably believes the offerer to be present in the state and the acceptance is received at the place in the state to which it is directed, and, 2, has not previously been communicated to the offerer, orally or in a record, outside the state. E. Publications, radio, television, or electronic communications. An offer to sell or to purchase is not made in the state when a publisher circulates or there is circulated on the 162 publishers' behalf in the state a bona fide newspaper or other publication of general, regular, and paid circulation that is not published in the state, or that is published in the state but has had more than 2/3 of its circulation outside the state during the previous 12 months, or when a radio or television program or other electronic communication originating outside the state is received in the state. A radio or television program, or other electronic communication is considered as having originated in the state if either the broadcast studio or the originating source of transmission is located in the state, unless, 1, the program or communication is syndicated and distributed from outside the state for redistribution to the general public in the state, 2, the program or communication is supplied by a radio, television, or other electronic network with the electronic signal originating from outside the state for redistribution to the general public in the state, 3, the program or communication is an electronic communication that originates outside the state and is captured for redistribution to the general public in the state by a community antenna or cable, radio, cable television, or other electronic system, or, 4, the program or communication consists of an electronic communication that originates in the state, but which is not intended for distribution to the general public in the state. F. Investment advice and misrepresentations. Sections 403, A, 404, A, 405, A, 502, 505, and 506 apply to a person if the person engages in an act, practice, or course of business instrumental in effecting prohibited or actionable conduct in the state, whether or not either party is then present in the state. 163 Official Comments. Source of Law, 1956 Act Section 414, RUSA Section 801. 1. Section 610 defines the application of the Act to interstate or international transactions when only some of the elements of a violation occur in the state. This section applies to all types of proceedings specified by the Act, administrative, civil, and criminal. The law is now settled that a person may violate the law of a particular state without ever being within the state or performing each act necessary to violate the law within that state. 2. Section 610 generally follows Section 414 of the 1956 Act, but has been modernized to reflect the development of the Internet and other electronic communications after 1956. 3. Section 610 can be illustrated in the context of a civil action under Section 509, b, by a purchaser in State A against a seller in State B. Section 610, a, would apply when an offer to sell is made in the state. Section 610, c, provides that an offer which originates in State B and is directed to State A is made in both states. The Securities Act of State A would apply under Section 610, c. 2. The Act of State B would apply also, under Section 610, c. 1. The intent is to prevent a seller in State B from using that state as a base of operations for defrauding person in other states. Section 610, e, addresses offers made through publications, radio, television, or electronic communications. The subsection provides a series of safe harbors for advertisements in newspapers, magazines, radio, television, or electronic media that either originate outside State A or that originate in State A but are directed outside the state to the general public. With respect to bona fide newspapers or other publications of general, regular, and paid circulation, the safe harbor requires that more than 2/3 of its circulation be outside State A. With respect to radio, television, or other electronic communications, safe harbors are specified in Section 610, E, 1, through 4. Section 610, D, however, provides that a person in State A who makes an offer to purchase as a result of communication described in Section 610, E, may cause the Act to be applicable if the offerer accepts the offer in the state. Section 610, D, defines when an offer is accepted in the state. If a selling broker-dealer in State B solely sends a confirmation into State A, or the purchaser in State A sends a check from within State A, the Act will not apply unless, under Section 610, D, the confirmation or delivery constitutes the seller's acceptance of the purchaser's offer to buy in State A. The applicability of the Act to purchaser is addressed by Section 610, B, which is the converse of Section 610, A. Under Section 509, C, there can be liability of purchasers to sellers. 164 Section 610, F, is a new provision that specifies jurisdictions in cases involving investment advice and misrepresentations. 4. Under subsection 202(20), certain out-of-state offers or sales are exempt from securities registration. 5. The phrase other electronic means is coextensive with computer or other information technology permitted by subsections 102(8), 102(25). 6. Under Section 610, the administrator may adopt interpretative rules or orders to specify when particular uses of new electronic communications, including the Internet, involve an offer to sell or to purchase a security, acceptance of an order to purchase or sell a security, or an act or practice involving prohibited conduct, within a state, whether or not a purchaser, seller, or other party is then present in the state. The NASAA interpretive order concerning broker-dealers, agents, and investment advisor representatives using the Internet for general dissemination of information for products and services, April 23, 1997, is an illustration of an interpretative order that would be in compliance with the administrator's authority under Section 610. Under this order, broker-dealers, agents, investment advisors, and investment advisor representatives who distribute information on available products and services through communications on the Internet generally to anyone having access to the Internet, such as postings on a bulletin board or home page, shall not be deemed to be transacting business in a state if specified conditions are satisfied, including a legend clearly stating that the broker-dealer, agent, investment advisor, or investment advisor representative may transact business in that state only if first registered, excluded, or exempted from applicable registration requirements. Section 611. Service of process. A. Signed consent to service of process. A consent to service of process complying with Section 611 required by this Act must be signed and filed in the form required by a rule or order under this Act. A consent appointing the administrator the person's agent for service of process in a non-criminal action or proceeding against the person, or the person's successor or personal representative under this Act, or a rule adopted or order issued under this Act after the consent is filed, has the same force and validity as if the service were made personally on the person filing the consent. A person that has filed a consent complying with this subsection in connection with a previous application for registration or notice filing need not file an additional 165 consent. B. Conduct constituting appointment of agent for service. If a person, including a non-resident of the state, engages in an act, practice, or course of business prohibited or made actionable by this Act, or a rule adopted or order issued under this Act, and the person has not filed a consent to service of process under subsection A, the act, practice, or course of business constitutes the appointment of the administrator as the person's agent for service of process in a non-criminal action or proceeding against the person or the person's successor or personal representative. C. Procedure for service of process. Service under subsection A or B may be made by providing a copy of the process to the office of the administrator, but it is not effective unless 1. The plaintiff, which may be the administrator, promptly sends notice of the service and a copy of the process, return receipt requested, to the defendant or respondent at the address set forth in the consent to service of process, or, if a consent to service of process has not been filed, at the last known address, or takes other reasonable steps to give notice, and, 2. The plaintiff files an affidavit of compliance with this subsection in the action or proceeding on or before the return day of the process, if any, or within the time that the court, or the administrator in a proceeding before the administrator, allows. D. Service in administrative proceedings or civil actions by administrator. Service pursuant to subsection C may be used in a proceeding before the administrator or by the administrator in a civil action in which the administrator is the moving party. E. Opportunity to defend. If process is served under subsection C, the court, or the administrator in a proceeding before the administrator, shall order continuances as are necessary 166 or appropriate to afford the defendant or respondent reasonable opportunity to defend. Official comments. Prior provisions, 1956 Act Sections 414, G, and H, RUSA Section 708. 1 Section 611 follows the 1956 Act and RUSA in providing for assigned consent to service of process in Section 611, a substituted service of process in Section 611, b, and process and opportunity to defend in Section 611, c, through e. 2. An issuer is not required to file a consent to service of process unless it proposes to offer a security in the state through someone acting on an agency basis. Since the civil liability provisions of Section 509, b, apply only in a suit by a purchaser against a seller, the issuer in a firm commitment underwriting is civilly liable only to the underwriter, who, in turn, may be liable to the dealer, who, in turn, may be liable to the purchaser. In contrast, in a best efforts underwriting, when the security is sold on an agency basis and title passes directly to the purchaser, the issuer can be liable to the purchaser. 3. Section 611, b, generally follows Section 414, h, of the 1956 Act and Section 708, c, of RUSA. The intent is to provide for substituted service of process when a seller in one state directs an offer into a second state either in violation of the laws of the second state or fraudulently. Under Section 611, b, the purchaser may sue the seller in the purchaser's state and then bring an action on the judgment in the seller's state. The constitutionality of this type of statute has long been sustained. For this section was originally based on the type of non-resident motorist statute whose constitutionality was sustained in Hess v. Pawlowski, 274 U.S. 352, 1927, and subsequently in other contexts. See, e.g., International Shoe Co. v. State of Washington, 326 U.S. 310, 1945, Travelers Health Association v. Commonwealth of Virginia, 339 U.S. 643, 1950. Section 612. Severability Clause. If any provision of this Act or its application to any person or circumstances is held invalid, the invalidity does not affect other provisions or applications of this Act that can be given effect without the invalid provision or application, and to this end the provisions of this Act are severable. Official comments. Prior provisions, 1956 Act Section 417, RUSA Section 805. 167 Article 7 Transition Section 701. Effective date. This Act takes effect on insert date, which should be at least 60 days after enactment. Section 702. Repeals. The following Act is repealed. Insert name of former State Securities Act. Section 703. Application of Act to existing proceeding and existing rights and duties. A. Applicability of predecessor Act to pending proceedings and existing rights. The Predecessor Act exclusively governs all actions or proceedings that are pending on the effective date of this Act or may be instituted on the basis of conduct occurring before the effective date of this Act, but a civil action may not be maintained to enforce any liability under the Predecessor Act unless instituted within any period of limitation that applied when the cause of action accrued or within 5 years after the effective date of this Act, whichever is earlier. b. Continued effectiveness under Predecessor Act. All effective registrations under the Predecessor Act, all administrative orders relating to the registrations, rules, statements of policy, interpretative opinions, declaratory rulings, no action determinations, and conditions imposed on the registrations under the Predecessor Act remain in effect while they would have remained in effect if this Act had not been enacted. They are considered to have been filed, 168 issued, or imposed under this Act, but are exclusively governed by the Predecessor Act. c. Applicability of Predecessor Act to offers or sales. The Predecessor Act exclusively applies to an offer or sale made within 1 year after the effective date of this Act pursuant to an offering made in good faith before the effective date of this Act on the basis of an exemption available under the Predecessor Act. Official comments. Prior provisions, 1956 Act Section 418, RUSA Section 807. Prior law governs all suits, actions, prosecutions, or proceedings which are pending or may be initiated on the basis of facts or circumstances occurring before the effective date of a state blue sky statute. See Hilton v. Muma, 522 F.2d 588, 600, 9th Sir 1975. 169.